A roundtable discussion on Bill 162-33 COR. Everybody should have a copy or the most recent version that we've put out. On the upper right-hand corner on the first page, it says March 28th, 2016. And then under the bill number, you'll see highlighted in yellow Bill 162-33, and then it says as substituted by the committee. Now what we've done with this version of the bill is, as you go through, we have highlighted where we made changes from the last several roundtable discussions, and that it really wasn't quite settled at one of the roundtable discussions. So what I've done is I've noted the change that we've made, and I've put a superscript right next to that line. And at the end of the bill, you would find, you probably want to just pull out your end notes, which kind of explains why that change was made. For example, the AG's representative suggested something. Maybe the rest of the majority of the participants did not agree, and so we just left it where it was at. So I would suggest that what we'll do is we'll go basically section by section, and we'll go to the highlighted changes, and if there's any further discussions on that, if none, then we'll basically let the change as noted stand then. Is everybody in agreement with that? So now I've got a sheet of paper that's going around. It's for attendance sheet, so please sign in, and we'll know who is here. I've contacted the OPA's office. They won't be the GSA, and they won't be attending today. But they've received all the notices that everybody has received here. Okay? So with that, then we'll go ahead and we'll proceed to those pages where the changes were made, and probably needs one final review before we decide to let it stand or make further changes. And so that first change will be on page 3 under the definition of responsible bidder or offerer. And on that there, it was defined as that the responsible bidder or offerer means a person who has the capability in all respects to perform fully the contract requirements and the integrity and reliability which will assure good faith performance as determined at any time before award. And the superscript of the end note number 1 there, basically the AG's office representative objected to that amendment because she deemed that it hampered the competition for off-island bidders, concerned that an off-island bidder would not be able to respond in a timely manner. I left the proposed change there on the premise that if the off-island bidder wanted to participate, he cannot use his absence as an excuse for preferential treatment. So if there's any discussions on that. None? Yes, ma'am.
The AG's office would like to follow up on that. The clause has responsible bidder or offerer. And so that includes your request for proposals. And the time of award for request for proposal, since they're signed by the governor, is the effective date of the contract. So there's a lengthier period of time. I know that award is not a defined term in the procurement laws or regulations. There's been some determination by the OPA. I can't recall whether it was a bid or a request for proposal that was looked at. So the only thing I would like to raise to the attention of the legislature and everybody here is that there are all different types of procurements, and some of them are more sophisticated and complex. And there's different licensing and other things that are now been considered to be part of responsibility as opposed to responsiveness. And the way it reads with the period, assure good faith performance period, works. Adding as determined any time before award is a limitation that may have a lot of severe impacts on some of the same things that you're trying to open up the flexibility of the procurement code and regulations. And so I just want to raise that to you. There are some procurements where unfortunately there aren't contractors on Guam, and so you also want to make sure that you're having full and open competition. Unfortunately, in some procurements, we find that even in the country, there's a limited amount of offerors that offer services. So it's not that there's always an abundant market of contractors. So I think what you want is the agencies to have the flexibility based on the type of procurement. And you still have that it comes in and you have the regulations and it's already occurring, and you have, as been pointed out, I guess it's in 3116 in the regs, as to what's involved in determining responsibility, as opposed to trying to fix a point in time.
So you would prefer to read that?
I would, everything that's highlighted in yellow.
Any comments to that?
This is where it gets really technical. This is where the leading side and depending on the argument and all, so I'm going to refer to in that area.
I think you're supposed to.
Can you speak into the mic, Anthony, so that, yeah.
Well, looking at all the changes in their totality, I believe the intent of the bill is actually that the purchasing agency would have to determine responsibility prior to award. And this new language kind of tracks with or harmonizes other language in the code that requires the agency to do that. That's all it does from what I see.
But the point in time when an award occurs is what comes into question. Sometimes there's a lengthier period of time. In fact, it would be all right, and we understand at the moment, there's the way our code and regs read is there's a determination of non-responsibility that's needed. Under the federal grant guidelines, they actually encourage a determination of responsibility for each procurement. And they actually have that as part of it, so that it would occur always. Because one of the things that has to do with responsibility is debarment, and that you need to check. And if it occurs between when the contract's in processing before the governor signs, it still would affect the responsibility. And that's what with the larger procurements, there's sometimes, because of the certification of funds and the routing and approval reviews, there could be 2.5, 3 months. So that's what before award is unknown. It's not a defined term. It's been interpreted differently by the OPA, and my interpretation of it, I'm saying it's the effective date that the governor signs the contract, because up until then, and that's what we put in the procurement, it's not effective until the governor signs.
Well, the governor doesn't sign all contracts.
The ones that he does, unfortunately, this clause has to do with all. If he were going to divide it up in subsections, we could do it. It's because it includes offerer. Most responsible bidders are based on a purchase order, and it's quicker. And that determination, and I think DOE's here, they do an evaluation, they check the debarment list, they have a whole standard process, and it occurs like that. But when they have to go through a request for a proposal, there's a lengthier time between when it's executed. And that's why I think it should still fall under responsibility. Because if a contractor went bankrupt between that time or something else happened, you'd want to look at whether they were going to be responsible to perform the new contract. The governor wouldn't sign it.
Well, what I'm trying to tell you is okay, under this bill, the responsibility determination occurs before the award. So
When is award, though, Anthony?
Well, it differs for, basically, it differs for different types of procurements. And it differs by agency. So some agencies, for example, they'll say notice of intent to award. Then at some point, when there's actual purchase order cut, that's the award. In other cases, there's an actual formal contract. Okay, but they're not. I would say that if you're going with purchase order, that's a 90% solution right there, comparatively speaking.
Well, and my response is that that discussion just shows that adding that phrase adds ambiguity to the written statute, because we can interpret award differently. As you said, it depends on the agency, and what I'm saying is it works with the rest of what's in here and the other regulations without adding that language, because it is going to be determined before award, right?
If it's going to be, I don't see then where you have a problem with that language, because that's all it says, is determined at any time before award.
Because before award is ambiguous.
Well, it's just we're just in the definitions here, that's all. And if you look at the later paragraphs that occur throughout the bill, what I'm trying to say is that's actually in harmony with some of the other determinations that this law would require the agency to make before the award. Because they're not just, the analysis is responsiveness and responsibility. So they're placing that on the agency before the award is made.
It's the current law now that it's before the award, and when you add a new statute, it top guards everything else that exists. So they're going to use this language to override any of the other interpretations or regulations that might be a little bit different than that. So if you add this in, our point is only that it adds, since it adds any time before award, and award isn't a defined term, then you actually are adding a little bit of ambiguity to your statute. It's not as tight as before. Leaving it out, you have the same ability to define everything because it's already defined that way. Is what we both agree on that.
Okay,
Agencies determine it before award, but since award isn't a defined term, adding, as part of a defined term creates the ambiguity.
Okay.
Right. Responsibility, I think we're all in agreement here that responsibility has to be determined before award. The thing that is missing in here is a definition of award, and I agree with everybody that there is no definition, and you haven't proposed one, because it is almost impossible to come up with one. I have worked on it for several years. But when you look at where the context of this is, it's in Article 3, which is source selection and contract formation. We're talking about the formation of a contract. These laws are built on contract formation laws that we're all familiar with. You have an offer, you have an acceptance, you have a contract. So you look at the offer is what the solicitation is. The acceptance, when you give an acceptance, you have a contract under regular private party contracting. And that's the same thing here. You have an acceptance at some point, but it's determined by when that offer is, and that is necessarily vague. You can go through Sabinic and Nash and all the other books you want to look at about procurement, and they all say the same thing that we're saying, and it was meant to here just state the law, because the problem that arises and why that language is in here is a lot of agencies find that they have to determine responsibility in the bid package by the information that is in there, and it was just to clarify that. And I agree, taking it out won't change a thing. Leaving it in will hopefully clarify that issue as to when that's to be done.
If we could take it out here and maybe put it at a later point as opposed to upfront.
It's in the regulations, because the responsibility is capability. Do you have the capability and the integrity? And capability is defined in 31011 to say that's before award.
We agree.
So that language is there.
We agree totally. It's just that when you add it here, it's of concern, because when you pass a new statute, it changes everything that's in the regulations already and in the other statutes that aren't actually part of the, that have already been passed and part of the code. So we're very cautious when there's a change, just to make sure that any potential impact of that. And if it's not, the same way we do procurement, it has to be very purposeful. If the purpose here is just to state something that's elsewhere, the request would be that it wouldn't be in the definitions. That's,
Okay, we're deep in the
Okay.
weeds, and
Yes.
I don't think we're going to resolve the question as long as there's no question amongst the advisors to the agencies that determination of responsibility is not made in the bid package, and the bid package has nothing to do with responsibility. But I've run across that on a number of occasions, and I think that the word needs to be let out a little bit stronger. Take the language out. It doesn't change it. It codifies existing law, and that happens as frequently as changing the law by changing some language. So, no big deal for me.
So as a compromise, I hear them say delete. Right?
Yep.
Okay.
thank you.
Okay, then the next change that still needs to be resolved is on line 25. This is on the definition of responsive. In particular, a non-conforming bid is non-responsive if it contains a material non-compliant term. And all that did was we changed the term that was in there originally proposed was the term non-conforming. So it would have read, a non-conforming bid is non-responsive if it contains a material non-conforming term.
Non-conforming is still there. 125, I don't know if that's compatible.
Well, no, it's just that we were, yeah, so instead of saying a non-conforming bid is non-responsive if it contains a material non-conforming term, I just had changed it to use a different different word for non-conforming. Yes.
This is where we see a lot of vendors come before OPA, and it's usually either with the delivery date area. And this is normally GSA. GSA will say 30 days, or GSWA will say 90 days, and a vendor will say 122 weeks. What happens then when you have that, the vendor is being very forthright and honest about it, but they automatically reject it, non-responsive, you didn't comply with my terms. That to me, I have a challenge with that, because what the agency needs to look at, GSA, is 90 days reasonable, or is 30 days reasonable? But the moment when you say this, the agency automatically rejects it. And then that's why we have appeals, because they've been rejected from the get-go. They don't even have a chance to look at their bid to see if it's still the lower bid. So I do have challenges that if bid is if it contains a material non-compliant to the terms and conditions, and delivery is always one of them. You even have certain areas with specification. Oh, you didn't do this, or and then automatically it's rejected, and that's why we get so many appeals, because of that one area, and then we have to debate, was that really enough to reject the vendor? And that's why we do get a lot of appeals.
Okay.
So I don't know how to resolve this, other than more education on the part of the agency. That my philosophy is, it's better to have more players so you can look at all the bids. You reject two bidders, one gets rejected, he ends up being the high bidder, as opposed to go back and evaluating the two bidders. And you're left by default because you've rejected the other one due to non-responsiveness. And that is a common thing that most agencies do. That's why we do. That's what most of our appeals center from. Rejection.
Now, for
due
those
to a specification requirement.
Now, for those bidders who are more savvy to this, they normally would come back and put in their specs as specified.
Yes.
And then
how do you
deal
know?
with it later, yeah.
Yeah. So, and those who are more savvy, in fact, I think I told you the last time, 30 days for an off-island product. 4 of the 5 vendors said, no way we can meet that 30 days. The one who got the bid was the one who said, as specified, because he was savvy. So we had put in there, we don't know from we can't assume that that vendor acted in bad faith, but we said, hey, if he doesn't meet that delivery date, you better assess liquidated damages, because you didn't pick the lowest bidder, because the lowest bidder said, I couldn't meet your 30 days. So, yeah, there are different ways to rig this system, but those vendors who are more forthright lose out.
Any comments? So,
I don't know what to say with this one.
I think it's in the same realm as the award.
Yeah. I'm just telling you, it's going to continue to happen.
I mean, are we saying that we should just leave that as we have it then? How we have defined responsive? I mean, recognizing...
It's just likely to result in more appeals, that's all.
Material non-compliant.
It all depends. In our particular situation, when we had the request for the top lifter, which took us 2 years before we finally got it done, one of the bidders indicated that the specifications that we put down, which was 20, 40, 45, was geared towards a particular manufacturer and vendor.
We've had that type of
And
appeal
what
also.
we did was we responded to them that there are other manufacturers in the United States of America that manufactures 20, 40, and 45. It was their problem that they didn't reach out to them and get some kind of commitment to represent them or whatever. So, to say that the specifications and everything else would jeopardize or whatever, in this particular case, it worked in our favor because we needed 20, 40, and 45.
20, 40, and 45 as well?
The spreader for the lifter.
Okay, yeah.
Because the containers come in 3 different
Right,
sizes.
okay.
And they were saying we can only do 20 and 40. That's not doing us any good when a 45 container comes in.
But I think in
And
your...
that's in terms of specification.
But I think in that example that you're using, though, I think the more fundamental problem was that as a result of that objection that the specs were being rigged for one bidder,
Right.
only to find out that, in fact, there was a lot more manufacturers that it wasn't. The problem was that it took about 60 days for the port to get back to GSA. But they actually found, I think, three manufacturers, like within the first week, that could actually meet those specs. But I guess the procurement division held off for until they get the fourth and the fifth.
They
Yeah.
did for whatever reason, but I
Yeah.
think it was more, they kind of dropped the ball when they reached that
Yeah.
comfort zone that, as far
Yeah.
as they're concerned, the appeal was meaningless because
Yeah.
he didn't. But in the process of doing that and everything else, again, the delay and everything else worked in our favor because the price went down.
Yeah.
We budgeted for 2, and with the price dropping, we were able to buy 4.
Sure.
So, sometimes it works your way, sometimes it doesn't. And in this particular case, it was in our favor. The time delay worked in our favor.
So I need some guidance then on how we're going to treat the definition of what we mean by the term responsive. I mean, we can leave it as it is, knowing there are pitfalls. Huh?
Well, I think the original language was, the first sentence, means conforming in all material respects to the purchase description and contract terms contained in the invitation for bids or RFP, so on and so forth.
Is that original language?
No, it's
I
under.
think it.
No, it's all new, right?
That's on the.
Underneath.
Yeah.
Yeah,
But
but
I
we
think
can,
it
we can take out,
counts-
I'm sorry. As far as the non-compliant goes, I have no problem with taking that out.
Well, for future uses, it would work in our favor, keeping that word in.
How many more top lifters you ordering?
No, we got other machines,
Yeah,
other
I'm just
heavy
kidding.
equipment,
Just kidding.
in which specification plays a key part.
Yeah. So what are you suggesting, Anthony?
I was just looking
I don't think the existing code defines responsive.
at.
And that's, we're just changing a word or something.
Unless I annotated this incorrectly and showed it as all underlined new language.
If we left the existing language as a responsible bidder means a person who has submitted a bid is responsible.
Yeah, so it's, okay, the original language is the first sentence, pointing out of 53 or 5201G, which is a responsive bidder simply means a person who has submitted a bid which conforms in all material respects to the invitation for bids. We could add the additional language, though, RFPs, RFQs, and other solicitation. I don't see anything wrong with that.
Yeah,
And
but
end it there.
subparagraph G defines what a responsive bid is, but I think in H,
Oh, responsive,
we're defining what responsive, the adjective responsive means.
That's yours.
All I'm saying is, with that term, that's going to be greater grounds for more rejections and more appeals with that word, material non-compliant term. And it's usually, it's going to be in the specifications or in the delivery time. And that's where, and they've had a number of bids just on an area of specification or an area of the delivery. Delivery was more common this past year. So just, it makes it more.
So I need some guidance. What are we going to do with this?
My recommendation is to leave the existing language that's already in the statutes under
G.
F and G.
Yeah.
For that, just for the reason is that since you are creating a statute without doing all the procurement regs and other statutes, you are going to create areas.
Yeah.
They're
Well-
going to place emphasis on a change of word.
Yes.
That isn't going to be what you intend, because you're thinking of the dictionary.
Now, yeah.
Yeah.
Now, insofar as the regs are concerned, I think we've all realized from the get-go that what
We're
we've
burdened
made
with that
changes here, the regs are going to, there's going to have to be changes made. So I think in the last section,
Yes.
it does put the task on OPA to go into the regs and make the changes there
Or-
to to conform to this.
Which I think was back in 224 too, and that's not an issue, but in addition to the regulations, the other thing that is present is the OPA has made different rulings, and so has the court, and so the terms have already been defined based on the phraseology that exists in those. And when you change a word in it, they're going to come in and challenge it based on the new statute, saying that, well, this word means, and it'll give them room to argue.
I think that the changes more carefully telling what responsive means was very important, because the existing law is quite confusing to people who implement it. And you know, not everybody out there who engages in procurement is a lawyer. They're mostly business people and clerks. And the existing language says a responsive bidder, so you're talking about a person, but the person is never non-responsive, the bid is. So the definition from the get-go is on the wrong emphasis.
Yes.
Means a person has submitted a bid which conforms in all material respects to the invitation for bids. And people say, if it's in the invitation for bids, it's responsive. And if it doesn't have completely exactly what was in the invitation for bids, then we throw the bid out, whether it's a 90-day bid or because you didn't have information there that is regards responsibility. So this changes that from being what's in the invitation for bid for being the language that is used elsewhere in the law, that specifications, not invitation for bids. You know, you have to be responsive to the specifications. That's what 3109 N2 is all about, is an evaluation according to the specifications. And it talks about the purchase description. Those are the things that you have to be responsive to, not just anything that's in the IFB. And this was clearly written to get around that confusion created by saying it's got to be exactly what the IFB says. And the IFB says you have to do this. And some of those things are not materially conforming or non-conforming. They're not material at all to the question of responsiveness. And that's the whole purpose is here, is to take the language that you find in Sabinic and Nash, going back years and years, that a responsive bid is an offer which unconditionally undertakes to provide the supply that the government intends to acquire. That's a more perfect way of saying what responsiveness is than just saying, well, if it's in the IFB, it's responsive.
But unfortunately, and that's good theory, but the reality is that will be a further emphasis. I want 90 days, you said 120, you're out. You don't even get to open the package. And so any slight deviation, that's good theory, but the reality is that the bidder will be rejected.
And on that vein, just from the language, if you look at H, after the first sentence, it goes beyond the definition of responsive bid by simply trying to describe what a non-compliant or non-conforming bid is. Is that really necessary for because the definition of responsiveness, you wouldn't really need a definition of non-responsive. Okay?
Well, again, you look to what the regulations in 3109M talk about in terms of what is a material change, what is a material mistake, what is material to the to the bid, and they talk about in that section, it's material if it prejudices other bidders. And so that's why it's the materiality. Responsiveness is all about materiality. If it's a minor change, it is not material, and it doesn't make the non-conforming bid.
But that doesn't how it works,
Well,
John.
you're going to always argue about what's material. You're going to always argue about what's reasonable. You're going to always argue about a lot of standards that the law customarily uses because those are facts basis. The award is a factual basis concept. There's no way you can define it that covers every factual possibility. And so we have to use terms like prejudice, terms like reasonable, terms like award. Award is we all took contract law for a year to try to tell us when you have an acceptance. What are all the concepts, all the ways you can have acceptance, by performance, by when is negotiation complete, all of those things. You can't define that. But that's what an award is. It's the final acceptance because that's what contract formation is. You have an offer and you have an acceptance. We have a solicitation and we have an award. It's the same process, and we have to think of it in those terms. So I believe it's necessary to talk about what is material when you're talking about responsive, because it is only a material difference that makes something non-responsive. And in the regs, they say it's not material if it is insignificant, if it's minor, if it's negligible. And they talk about in specific reference, it is negligible, it is prejudicial to other bidders. And it says, and then it goes on to describe what we mean by prejudicial. It says that is the changes having to do with quantity, quality, delivery time, and contract terms are prejudicial if they are more than negligible. Broad terms that we can argue all day long about facts, and that's why we have the courts is to argue about facts. But we're trying to get the law specified more clearly here, so people who aren't lawyers and they're looking, okay, I've bid on this thing. What do I do here? And they're making their way through it. This is supposed to be used by laymen. This is
And if that's the case, I would suggest we delete the last sentence. If this is, responsive means conforming in all material respects, period, and leave it at that. Because the rest, it just gives the agency the excuse, hey, he said 90 days, he said 120, I want 90, you're out. And we're going to get bids like that because we're emphasizing non-compliant with this thing. We're emphasizing it as opposed to saying it's not material. the interpretation by lay people, people in procurement are lay people. They're not lawyers.
We're moving beyond the thing that you've highlighted here, non-compliant. This is how many roundtables and hearings and things
This is
later that we've been down this path over and over and
No,
over
we
again. And I
haven't.
think
We
we're not going to ever get the
Consistent.
reform that this bill's going to introduce if we keep having roundtables where we never conclude, because we keep going back over the stuff that was introduced and discussed before. Just a point of order.
Any other comments?
I unfortunately wasn't at the other roundtables, although we've read and watched the DVDs, and we've been following what's going on. But I just would, and it's going to be a standing request throughout the rest of the review of the bill. The AG's office strongly recommends that if there is an actual case that is being overruled, or another section of the law, like the open government law and sovereign immunity that's being affected, that there be a clear discussion of that up front in the discussion of the bill. There is not at the moment at all, and that's of great concern, because the court's going to look, if there ever is a question, and so will the OPA, as to what is written in the law. And again, from the same standpoint of clarity and purposefulness, my understanding is that all the changes that are being requested are for a specific purpose, not just to change the language and make things that are already written in the regulations and are clear there, which I just want to point out, and John is an excellent teacher and has been. Those are in the regulations, the language that he's just shared with us, and they're open. We always direct anyone that's procuring on island or off island to both the procurement law and the regulations. And the regulations, if they're unclear, in keeping with what's already in the law, the OPA is going to have that opportunity to review as part of passing this law. So if there's something inconsistent with that. So we just want to make those points stand
I'd
throughout
like
the
to
whole
agree
bill.
with Laura on that. I think there have been several efforts to make findings, basically why this is coming to be, and that gets more extensive than the actual bill. But I look to the comments behind all the sections to get a better sense of what they are. Even in the model code, the ABA model code, which we model after, they have very excellent comments, and and not as legislative findings, but comments that follow the bill, and it really helps people understand what they're doing. I've been told that I don't know if it's true or not, I've never spoken to the compiler, but the compiler feels that could get way out of hand if we start having legislation with a lot of comments, so that they don't want them. But I agree that can be very elucidating.
It's usually in the preamble to the bill that I've read it, when it says this bill and is being enacted, and it specifically says, like, it's overruling, and I'll use, for example, fleet services or some other case, that you're changing. The purpose is to change that which the Supreme Court has already ruled upon, or to clarify something if there's been cases that have gone different ways on the same issue. So that's where I usually find it. And yes, I believe that everything that's been presented since I've been watching all the sessions, I highly recommend everyone watch this just for learning, because the knowledge that's in this room, and then when GSA is also present, is just invaluable to anyone trying to do procurement on Guam. So the comments would be, unfortunately, they're like endnotes, and they're going to be lost. Yeah.
Okay, well, based on the discussion we've had, I think we can go 6 of one, half a dozen the other. I'm going to leave it stand as it is. Okay? All right.
Expect more appeal.
The next set of changes was on page 5 under the section 4, an amendment to section 5211 competitive seal bidding. And starting on line 9, the determination of bidder responsibility is determined as specified in section 5230 of this article and not by information requested by the invitation for bids. Again, the OPA did have a concern with that. The objection was that the intent is unclear. But I know, John, I believe you had commented on this, that basically in section 5230 really kind of provides the parameters of determining responsibility, and not so much, I guess, standards as we go along, right, with changes with every bid.
It's been my experience through numerous classes that I had the discussion with hundreds of people that it's very difficult to get your arms wrapped around the difference between what's responsible and what's responsiveness. And in doing some of the suggestions that I had for this legislation, I wanted to try to add, without the availability of comments or other things, guidance is to say that they are separate, they're separate subject matters, they're separate standards, and they're determined at separate times. And that just needed to be reiterated, and that's what this language is to say, is that it's determined according to the rules of responsibility, which actually defers to the regulations in 3116, not by what's in the invitation for bids, because constantly we're saying you don't have a qualification statement that tells us whether you have these people. Well, people is a question of responsibility, and they shouldn't throw a bid out for that, but that tends to be the tendency. And when you talk to people, they say, well, that I don't understand now. It's because we've had 30 years of mistreatment of what is responsive and responsible. In fact, I had GSA tell me when I first started into this stuff that there is no difference. They're the same thing. If it's in the bid, it's responsive. That's it. So I think that we have a long way to go to clarify it, and by adding clarification in the legislation, we're actually doing a bit of reform in education.
I would agree with that. There is a lot of confusion. Like one of the earlier cases, it was a whole issue with J&G as to bidder responsibility and responsiveness. So this will take time to eventually flesh out.
Laura?
Our concern was not on that one. Our concern was on the next one, but you clarified it. We didn't have a concern on that.
It was a public notice issue.
I just wanted clarification too, and that's what, as far as, because the other concept that's prevalent throughout procurement is that the government or the writer of the solicitation is the master of the solicitation. And so they can put things into a IFB and a RFP depending on what the nature of the procurement is that's happening. And I'm seeing more and more from the federal government questionnaires and things that have to be completed by the contractor because they submit it so it can be reviewed as far as responsibility goes. So even though it's determined later, they're able to ask the questions so they have the information to know whether they can ask additional information. And with some of the procurements that I'm involved in, there are a number of things that have to do with compliance with programs or specific needs and coverage and things of that nature. And I myself find that in some respects, if it would be responsiveness if it's in a certain nature, a factual nature based on that procurement. I note, and what I wanted to ask was, and I'm connected to the wage determination. I had a case at the OPA and learned the hard way about that early in time. I noticed that it's being stricken from B, and I just want to make sure, because second sentence is then talking about responsibility. But the actual submittal of the written declaration that a contractor is going to comply with the Service Act and the benefits that are there, I would believe that that is responsiveness. Whether or not they're even capable of doing that would have to do with responsibility. But whether or not they comply with the requirements under Government of Guam law and state that they're going to comply with that, that would be responsiveness.
Well, let me,
And that's what I wanted to question that because I noticed a deletion and it's going to be a change in law that we have to deal with.
well, going back to the wage determination, and we did have a case before the OPA, and in terms of who actually, basically, neither the OPA or the OPA does not have the authority, essentially, to go and enforce wage. It's the Department of Labor. That was made very clear by
Right.
statute, very clear in that decision. I understand that really, if the wage determination as required by 5801 and 5802 are to be in the bid package at all, a simple declaration will comply with that, I think would suffice. Further, in terms of what goes in the IFB, it's very important that the purchasing agency, as we also mentioned in that particular decision, put in their bid packet whatever the existing wage determination is. What's happening is what happens otherwise is the different contractors will have different wage determinations. Some may not be the current one, and they'll say this is what we'll comply with.
The
Okay.
current,
So it's not uniform.
yeah, the current, what he's talking about, the current rev of the USDOL, it changes, and it's the time of contracting that the one that applies. And at the time, the publication and the training has been, and maybe there's some areas that are still learning, but the training has been when the agency publishes their IFB or RFP, they include an Office of Attorney General Form 006 with a copy of the, and that the contractor returned that form with the most recent rev of that. And if there's a delay in the process and it changes, then the form goes out and they have to sign a new one if it hasn't been awarded and there's a change in that. They have to check it before the time of contract execution or award. And if there is a change in the contractor's bid, the contractor has the ability to come in and show that it's based on what that change in that USDOL wage rate is that's causing that. So there's an ability for movement. And every time a contract is renewed, if there's an annual renewal, they have to get the Form 6 and they use the most recent one. So I applied learning that I learned in the OPA, but I just wanted to make certain that by removing this from up here in the invitation for bid, that you're not now, there hasn't been a discussion that is because it goes to responsibility versus responsiveness. Because if we didn't get the form back, that would be a non-compliant with one of the requirements of the bids and the proposals under Guam law.
If we look at the step back again, we're up pretty close to the trees, and I think we're getting disturbed by the branches. The wage determination is an obligation of a contractor, someone who already has a contract. And if they don't pay it, you can't tell whether they're going to pay the wage, and you can get an affidavit from them. You might be able to say that it's a provision, just like a disclosure requirement. You make an affidavit that you will comply with the wage determination laws, but you don't know. You can't tell when you're trying to review it whether their bid price is low, but maybe they have savings in other places and they're going to be able to pay it anyway. You can't determine if the bid is responsive or responsible in the solicitation process. It doesn't belong in here. And when you look at the requirements of the wage and law benefits in Article 13, it glosses over all of this stuff that says contractors have this obligation to. Of course they do. We're not saying that, but this has, if it's going to go through the solicitation process, it's going to flop on the table of the OPA. They have no jurisdiction to decide a wage determination issue. That's Department of Labor. We need to start paring this back. You talk about making changes that really affect the law. This was thrown in 2007. It's not that long ago, and it has created an awful lot of disharmony. Not to mention the paper that you have to add in just to have all those wage determinations. That most of it is irrelevant because you're talking about one or two positions, and you have to have about 30 pages of paper added to your bid document. It's a waste of time. That's why it was stricken out.
We would say that is a very important part of bids and a request for proposals, that contractor is going to comply, and their declaration of that up front is extremely important. And we get a flow down, especially when we deal with federal contracts. There's a lot of other compliance requirements that we go to from EEOC. Are you going to strip that out of the contract as well? Because that's enforced by a different area. The OPA is enforcing, and we're talking now in the protest and the method of solicitation, they're enforcing whether or not the agency is reviewing what it's asked for as far as responsiveness and doing it in an appropriate manner. And the number of forms that can be attached to it. I mean, I just looked at something that had, it was 248 pages because it was through a federal HUD type program. And the forms that go along with that, and anyone that's involved in federal procurements at all know that we have to flow those all through. Limited English proficiency, that's another one. Those are common forms these days, John. And the wage requirement, having it in there, I think makes the law compliant. We find out up front. If a contractor's not going to sign that, why wouldn't they?
Yeah, but this language that's been stricken doesn't say anything about an affidavit that they will comply with it. This only says that you have to include a recitation of the recent wage rates. That's all that was required, and that's all that's taken out. The law has never said anything. If it's important that you have that affidavit, I'm not opposed to that. I'm just saying, and that it doesn't belong in here.
That was the purpose of my question, is I wanted to clarify that, because for the same reason, that once the new law comes out and this is taken out, people are going to challenge us when we put the AG procurement forms as part of it. And the understanding I have from our conversation and the discussion going on is that, yes, it's a matter of responsiveness, and it's a form that...
That's where we differed a little bit. I'm not sure that it's a question of responsiveness. If they don't provide the affidavit, that would be a question of responsiveness. But if they sign it and don't perform, you're way past responsiveness. They've already got the contract. So you got a contract dispute at that point. That's where I would differ.
Actually, you have a wage and hour dispute, because it would be with the Department of Labor,
And
not with the OPA.
Well,
or
if you have an affidavit, it could turn into a contract clause.
Well, and what you need to know is that the Guam Department of Labor will go after the procuring agency because they didn't include language and they haven't enforced it. So,
there's no,
so the
there's no existing
agency's
language
involved
that
in it.
requires
So we're in agreement that it's a matter of responsiveness, and that's why I just wanted to make clear. It's just because it's a change, and then afterwards we start talking about responsibility.
Well, we're in the context of everything that has to be in an invitation for bids and what does not have to be in an invitation for bids is matters of responsibility. That's all that says.
So my point of clarification is there are sometimes, and that's what, because of the language in that is a little bit broad, there are sometimes questionnaires and forms that are included in the bid that ask the offeror or bidder to submit information.
Yes, but it's not a question of responsiveness if the matter is truly one. But you're dealing with some of the gray area when you start getting into the negotiated contracts, which is what the federal government likes to do, and a lot of in service contracts in particular. Issues that we all used to think of the responsibility are starting to look more like responsiveness. If you require that they have 10 years of good performance, that's a question of responsibility in the abstract. But if it's what you're asking for, because you have a service RFP, you're trying to get some services, and obviously to define the service, you have to say, well, you have to have these qualifications to do it. So in the abstract, if it was a supply, that would be a question of responsibility. But in the context of a service, it took me a long time to figure this out. Sabinic and Nash has got some great stuff on it.
Okay.
but you got to keep them separate. That's the whole point.
Okay. So we'll leave the lines 9 through 11
After 1 hour, we're on
as
page
stated.
5.
On line 15, that was highlighted simply because of the question that was asked about, we state there, the regulations promulgated by the policy office. We really don't have a policy office in existence right now.
But that's existing language.
Yeah. But what we did was, because the question was asked by the OPA, who is the policy office? We haven't had anybody. And in the end notes, we indicate that in section 41 of the bill, we added the additional language to the policy office. The Office of the Public Accountability shall perform as the policy office until the office is established with its full complement of members. And so that's when that question arose there, I put the end note to indicate that it's the language, the clarifying language is back in section 41 of the bill. Yes, ma'am.
With that issue, I just want to say there was no issue as to the OPA writing the regulations that go along with the statute, but then putting her in place of the policy office potentially could have some issues with it. And I understand that, and that's what it has nothing to do with the competency, integrity of the people performing it, but due process and all of that involved. If she's writing the regulations, enforcing the regulations, and auditing everybody, it's not as separate as perhaps. And I'm also, under the ABA model code, there are 2 methods. And the government of Guam has the one method where we have a policy office, but the other method, B, is to put everything under the chief procurement officer. And since there's training and qualifications and hopefully, that more support in that role as a professional role, that's another potential for it. But
Just as a point of order, the composition of the policy office is not in this article. It's in Article 2, and that's a subject for another day.
I just am just raising that we researched a portion of the issue, and as to having it on a continuing basis and replacing it overall, as to future regulations, that might be something that is an open issue, and mine is just to advise you.
Okay. Thank you. So noted. Page 7. The issue there is on line 2, where we just added, the head of a purchasing agency, and I guess we were adding the phrase, purchasing agency issuing the solicitation, so that then basically we have the chief procurement officer for basically all your line agencies, the director of public works for construction, and then the head of a purchasing agency issuing the solicitation. I guess like GPA, who's
Not just GPA, but those governmental bodies that are exempted from the centralized procurement regime. So there would be GPA, for example, GCC would be another one.
they've been
DOE,
granted the
another
authority to carry out their
The
procurement function.
real clarification here was it says that this determination has to be made by the CPO, the Director of Public Works, or a head of a purchasing agency. So it's just to clarify, not just any purchasing agency can write that determination, only the head of the purchasing agency issuing the solicitation. It was a
Yeah, I don't have any.
very small change.
I don't have any
Okay.
problems with that language
Yeah.
at all.
All right. Any discussions on that? None? Okay. On paragraph G there regarding awards, this had to do with on the issue of posting to the website of the agency on any contracts awarded that's greater than $100,000, and shall remain posted for no less than 180 days or for the term of the contract, whichever is greater.
I just wanted to point out, it looks like a grammatical error that's all. And that's on line 10, page 7, where it says contract awarded in amount. I believe it should be contract awarded in an amount
Okay,
greater than, just grammatical.
okay. All right. Any further discussion? On page 7?
Just on the posting of the contracts,
Yes?
I just mentioned that I'm seeing contracts that are very large. I noticed at the OPA website, and even that when documents are up there, that there's not enough. They say contact them because they're too large to post. And I know that from viewing different agency websites and everything like that, that there is not the bandwidth out there. Not everyone has a website that's capable of posting large documents of that nature. And my other concern, and it's just because I'm dealing with a lot of database information technology things at the moment, is the wisdom of posting all your contracts that have to do, even though they're public records and they're accessible and all of that. The cost is involved, but when you have your infrastructures and your schematics and a lot of things that are part of your contracts, I think that some caution should be done with this clause as to, so that it's, I think it should be thought through if you're going to have everything posted. It's all available if there's a request for it, and they are, I think, I forget what the repository at DOA, and it depends on the different agencies. Does DOE have the bandwidth to post all their contracts?
There is a requirement that you're supposed to have a summary, like the vendors, who your contracts are, but not necessarily the contract itself. There is a requirement, but I don't know all of it offhand. And the problem with that is, like anything else, if you don't monitor it, people don't do it. But to have the actual contract, it's certainly notice of who has the contract, I think is important. You know, like ABC Company for 150,000, or like in our case, a teammate for, you know, electronic work papers. But whether or not the contract itself has to be posted is, I think she raises a valid point. But certainly, as a minimum, who has the contract? The term, you know, the general terms, like this is a 5-year contract, or, you know, with so-and-so for whatever, beginning, ending, total amount, you know, I think, and there is supposed to be something like that now, but like if I were to do a whole test, I bet you we're not going to find out, we're going to find a lot of non-compliant entities. But she does raise a good point about the actual contract itself, and maybe just a notice that is available.
Because we're talking all across government of Guam.
Yeah.
You're talking about a large number of documents.
Yeah.
And I know, and that's what, when you had, and I guess it's in 2012, when you had a panel come into town, John, and you were part of it with Schooner, Mr. Schooner or Professor Schooner, you said that there were 4 different elements that were always, he brought out, there were 4 different elements that are always present in procurement law, and it's a matter at different times of having to balance them. And so the reason I raise this isn't that we don't want to have open transparency and in keeping with open government laws, but it's the question of cost and the reality here in Guam at the moment as to what you're looking at in that. And I know there's a need, but I don't know if the need is actually as broad that the cost is going to be there. And I don't know if anyone's costed out what that would, the contracts I look at are in boxes from IFBs and construction, especially with the drawings.
Even us, when we do appeals, you know, we're supposed to post the entire procurement record, but when we see it, we say, if you want to see it, come into the office to see it, because it would consume so much megabytes. And we do have a number of appeals like that, especially when we get them from DPW. So Laura raises a very valid, I would like to see as a minimum, and maybe emphasize here, that you have to post the terms of the contract,
Right.
the vendor, the terms, the amount, the period, what it, and, you know, like for air conditioning for cars or whatever.
I know that I believe in the section dealing with sole source procurement, I think we had something in there,
To
the
that effect,
requirement
yes,
to this
yes,
effect.
yes.
Who was awarded,
Yeah.
what was awarded,
Right.
et cetera.
But there aren't so many of those, I hope.
But,
We
but,
won't know.
You know,
We won't know.
I think it's a good warning that this is going to take, it's not really the bandwidth, it's not really the, you know, I just bought a little bitty thing like that, 3 terabytes, for the same price I bought one 3 years ago for 250 gigabyte. So the cost on this, on the server time is
sure.
coming way down real fast, and it's not a question of bandwidth because we don't have bandwidth here on Guam anyway. But your problem is really the cost of getting the stuff so that it's readable over the line, and that is time consuming, it's labor intensive, and I can appreciate it. But if you look at a contract, almost everything is an attachment. And if you got the contract itself, regulations can say the contract includes the basic contract terms and not all the specifications and everything like that. And you can have a reference. It can be done by regulation that you can have to give notice where they can go actually obtain all the attachments, all the exhibits, all of the plans and specifications, all of the other stuff that go into the contract. I know they can get very, very lengthy, but that doesn't defeat the spirit of this. This is just to say if the contract is out there, you should be able to look at it, get the gist of it pretty quickly, and if your interest is really slated, not slated at that point, then you can go downtown or wherever you're going to do. But you got to make it available. That's existing law. That the procurement file is available.
Yeah, I would like to add that in addition to cost, because and I have seen this, and this discussion does concern me, because there is a security component of all of this. If we are posting the schematics, for example, of our siren, or of our tsunami siren, emergency sirens, or our telecommunication schematics, which the telecom bid is, a very intensive bid, so that anybody sitting in Russia at midnight could download it, and we don't know who that person is. That's a concern. Right now, if you went to DOA and you FOIA'd it, we know who you are. We know who asked for this stuff, and you, the requester, pay that cost to retrieve it, and that's fine. But to just float it out there in the great global world for anybody to just look at anonymously, I think that that's something that maybe that's not such a wise idea.
Okay.
So I could see putting a contract and executive summary, or even just the basic master contract itself, which really is only like something 17 to 20 pages. And if you want the rest of it, sure, come in, fill out the form and, pay the cost. And that's already the regulation for that. But I am concerned that if boxes of drawings and schematics are just going to be, out there, that's we might want to just think a little bit more about that.
Okay, so to Laura's point, I think it's been noted. We'll go back and we'll take a look at the language on the posting requirements and be more specific that maybe it's just a summary of the who, when, where, but not all the schematics and all. Okay. And so when we draft that new language, we'll put it together and then we can just send it out to you and see if anybody chokes on it or what. Okay. Any further questions on the posting issues, the length of time to be posted, no less than 180 days, or for the term of the contract, whichever is greater? And then on line 23, on the construction bids, I changed there was simply for construction bids, it goes to the Director of Public Works, but in this case, in the case of we also added the head of the agency issuing the solicitation, which would then cover for example, GPA or GW. Okay. All right. No further discussions there. We go to, yes.
I just wanted to raise, I know that there's added language, economic considerations preclude resolicitation of work or reduced scope. My understanding is that when this section comes into being, is you put out a big procurement and you don't have enough funds to do it, but the lowest offer is within 5%. Is within 5% of what you funds. And what you want to do is be able to go into negotiations with them. And economic considerations preclude resolicitation adds another limitation to the whole thing that kind of questions it and slows it down and adds a challenge to it. I'm not sure what the purpose is. If what you wanted to do was, my understanding of the clause is that it's to eliminate the cost of having to do a resolicitation because you're so close, and that's it. If the agency can negotiate it down within the realm of what it needs to do is why you do it. Adding this in kind of leaves me in a gray area.
Is part of existing law.
It
And
is
it only applies to construction bids because construction is scalable for the most part. But if you need 100 vehicles, you need 100 vehicles. That's not particularly scalable. I mean, unit-wise it is, but your need is pretty obvious up front. There's no ways of changing from a latex to a water-based paint or something like that on that kind of thing. I don't know why they had it in the law either originally, that you can negotiate this after bid opening with someone to change the specs, basically the quantities of the contract. But we also have some deviation for up to 10% changes in quantities for supplies and services under the change clause, change in quantities clause.
Would it address the concern if then on line 24 we say the Director of Public Works is authorized to negotiate an adjustment of the bid price and take away that qualifying circumstances of in situations where time and economic considerations preclude? I mean, it seems that that's where your concern
That's what
is.
my concern is, and actually it's new language that's being added because there's already language that permits this.
Negotiation?
In construction, I thought it was under 5 GCA 5211G, the original language. I wasn't sure why we were changing the language. And that's what, yes, it addresses it if you take out that condition. Because you want the head of the agency to be able to move with, you don't want to delay your procurement if it's that type of procurement and you're that close.
As I read this section, it seems to say that once you've chosen your lowest responsive and responsible bidder, but is costing too much, then you can play around with the prices.
If
And
it's
I think
within
that
5%.
Within
5%.
5%.
And I think if you open that door to that, just any solicitation at all, you're going to, sometimes he won by the low bid margin of maybe 1 or 2%, maybe a few dollars. And so 5% gives him an opportunity to recover some of that lost ground. I just think that I don't really like it in the construction context. But I'd be very hesitant to open the door to allow the government to come in and renegotiate up to 5% of the price after they've already determined that you're going to get it. That may not make them the low bidder anymore.
The only reason there's a negotiation is that the government, in good faith, doesn't have funds to cover the lowest bidder.
But you could put that out so everybody gets the benefit of that. The next guy can say, well, I can come within 5%. Heck, I was only 1% away from him anyway.
But then, John, they're all going to come down to 5 or whatever that number is.
That's right, and you're right back where you started from.
That's correct.
So I wouldn't want to open the door any wider to this.
Well, you're saying that if we remove that phrase, in situations where time and economic hardship that if we remove that phrase, we're opening the door wider. And I think that's what Laura was concerned about. That phrase.
Well, I would, if you take that out in time where circumstances preclude resolicitation, what are you left with? You're left with all the other times where you have all the time in the world to do it.
Well, this would kind of be a narrow exception. That's kind of why I like the existing language. It's a very narrow exception. So generally speaking, if the bids exceed, all the bids exceed the funds,
5% of my funds, my budget.
Or just generally speaking, this is our budget, none of the bids came within it, then essentially I could either cancel or reject all the bids, and then resolicit, okay? But here, this is just a very narrow exception as I read it, and it's only for, it's only for construction bids, and it's only in situations, of course, that's why I like this language, where time or economic considerations preclude resolicitation of the work. That's the only time it applies, and they're only negotiating here with the existing language. You look on page 8, line 1, with the low responsive bidder. So, and I think that would help. That low responsive bidder is either going to reduce his price, his or her price down to the budget, or they're going to have to go resolicit if these negotiations fail. But I see it as a very narrow, well-defined, and enforceable provision or exception.
Well, it's not just price that they're coming down, it also includes changes in the bid requirements. You can decrease, in consonant with your price decrease, you can decrease the quality of the product, you can increase the quantity of the product.
Yeah, well, for construction, that's how you negotiate a cheaper price. Maybe I don't want the granite, maybe the regular
that's
concrete
it.
will do,
Yeah.
so things like that. I think everybody who's built a house understands that process. So.
Okay.
I'm happy with the language.
As am I.
We'll move on. Page 8, competitive seal proposals. Let's see. What was our end note there? The language was amended to simplify and clarify. So this is a new section that we're including. And I think the discussion was much longer, so we just simplified it down to what we have right now that's highlighted in yellow.
What's a new method of procurement?
Yeah, the competitive seal
Yes.
proposal.
Well, it's actually, it used to be part of the law, then they got rid of it, and then this bill would put it back in. So it used to be part of the original Procurement Act.
So basically, the competitive seal proposal price is not the determining factor, correct?
That's right. Price is one of the factors to be
Right.
determined in the ultimate award.
And I think in here we were even more specific to the extent that price will not be more than 50%
Yes.
in weight. Okay, any comments on page 8?
For page 8, or just real quick, if we can just go back to, so I think it's just another grammatical error. This is page 8, line 7. This is more for John. John, is this, okay, where it just says purchase descriptions, market feasibility, or just mean to say feasibility? Was market, did you intend to put market in there?
Well, no, the purchase is, some things involved how you're going to write your specs, but the other is, can the market provide it? That's market feasibility. If the market can't provide it, it doesn't matter about
Well,
your purchase description. So
I just wanted-
that's what that
I
was.
thought it may have been a grammatical error, but if you intended, I don't have any problem with the language, but okay, just pointing that out. But speaking of grammatical error, on page 9, line 2, this is going back to competitive proposals. where it says or line 2, where it says source selection is required or as appropriate. Would it be more appropriate to say or is appropriate? That's just another grammatical issue as well.
I lost the line.
Page 9, line 2.
Line 2. Way up there.
Is required or is appropriate. Is instead of as appropriate.
I wouldn't have any problem with that either way. I still haven't found it, because line 2, mine says proposal method shall not be used.
Page 9. Page
Page
9.
9.
Page 9.
Yeah.
Line 2, where it just says source selection is required or as appropriate.
Ours says the competitive seal proposal method shall not be used.
Yours is different.
Mine says, line 1 starts with competitive proposals, period,
No,
and
no,
shall
but
not be
still
used.
Should be the same.
But it's
yeah.
still numbering.
When another method of source selection is required.
Or
We all have these.
as appropriate. Huh?
Looks like we might have different.
Can you,
25, 26 on page 8.
Okay,
page,
down here.
page 9.
Yeah, I don't know why you got that one. This is what,
For us, it's
There's-
page 8 on the bottom.
Page 8 on the bottom. Oh, okay. Shall not be used on another method. Is
Oh.
required or as
Shift it?
appropriate.
Okay, shift it.
Yeah, is is fine.
okay. Sorry about that. No, I got this off this was sent to me the other day, so
Yeah, well, I
don't
got
know
mine
what
on
the-
page 9.
Yeah,
Okay.
mine's on page
Mine
9
says
too.
page 9 too, but anyway, it's just a simple, if the sentence, or just to give effect to the sentence or the intention of the sentence, it just, instead of is, or instead of as, I think it should be is, just from a grammatical point, that's all.
Sure, okay.
Uh,
All right, anything further on page 9? Go to page 10. There was the issue of evaluators. And let's see. The representative from the governor's office recommended that the evaluators do not have to be government employees. So here then we indicated all evaluators must be persons acting in the best interest of the government with sufficient knowledge.
The last sentence there is to that point.
Evaluators
may be non-government employees.
may be non-government or non-agency employees. So that's the change that was made. I should have highlighted that. Okay. Yes, Laura.
I'm, competitive seal proposals with the change that's coming up later in 5.2, or section 9 on, page 17. For, RFPs
Yes.
as we know them,
Yes.
causes me some concern because there's going to be an impact on government of Guam procurement that I don't think is, are going to be understood right away. If you go to professionally licensed for your RFPs, as opposed to the current definition that's under fleet services and that, where we allow other professionals, and it's not limited to just professionally licensed. There is going to then be a requirement, if you do that change, that a lot of the small human service nonprofit types of procurements have to go through this competitive sealed proposal process. And I attempted to draft based on what you have in the bill, because I'm interested in being able to comply with the law once it becomes law. And I found this section to be very confusing and hard for a less sophisticated agency maybe to try to comply with. And I know a lot of the nonprofit organizations, and I'm thinking of Guam Behavioral Health Wellness Center, Public Health. A lot of funds come through, and Department of Senior Citizens, for federal funds, and they take it out and they procure taking care of their whole program. And those are going to be under the new law. And weighing all of this and the multi-steps as part of it is going to be very hard. And so I have not found another state that actually matches up, and that's what I haven't seen a model for this particular competitive sealed proposal. I know at the ending of your last session in January, because I watched the DVD on it back in the special proceedings, and there was questions because we came back to this competitive sealed proposal. And if we don't have a model that we're following that's like a state and local government, it's going to make it harder too to make sure that we help the smaller agencies. And John, you said you were confused. You weren't sure where all that language was drafted, or someone else had drafted it.
It was informed by the model code. The ABA model code has always had comparative sealed proposal. We adopted the ABA model code initially, as Tony pointed out, and then removed it because it's a hard thing to do. You got to learn how to do it. But almost every solicitation of any size in the federal government uses this method, and they beefed it up actually in their amendments made in the year 2000 to include more flexibility in this this comparative sealed proposal method. Let's call it best value. That's what it is. It's a best value approach, and everything that they do is modeled on a best value approach. They chasten under the lowest bid process, and they're not even particularly fond of the multi-bid process. The government has been pushing them to do that, and there's a lot of pushback in the services saying, no, we want this opportunity to have trade-offs. So, and when you go through a lot of their decisions, it's a very complicated process. We're not going to get it right overnight, but we've got to start learning how to do it because this is particularly best served in service industries. And procurement has gone from buying things to buying services more than anything else. And you can't buy a service on a low bid price because you have just too many various factors that you have to weigh. You can acquire professional services under an RFP method that we are quite used to, but in that one, price is the very last factor. The difference is in an IFB, price is the first factor because everything else is the same, responsive and responsible. So it's only price that determines the winner. In an RFP, as we have it for professional services, it's the last thing you consider, and it's kind of an afterthought. You get the best qualified person you can get, and then you negotiate a reasonable compensation. So it's the last thought. This one, price is something to consider up front as part of the mix. So they each have a way of dealing with price that's different and appropriate for different circumstances, and whether it will work for a small nonprofit or something like that, the way the feds do that is they say, well, we're going to set aside 23% of all of our budget for all the Section 8 and HUD type Native Alaskan tribes and all of that for all of those smaller purchases. And we can get around to making those social welfare programs work for nonprofits, but not at the expense of eliminating this very useful method of source selection.
Yes.
I recall this, this is a new area, and whenever you do have a new area, there needs to be a lot more guidance in it. And I do agree with John, because as we've looked at different solicitations, I think the JFK is a classic one because it was an RFP as opposed to design build, as opposed to an IFB. And the price was really way off the area, and once you selected that person, you didn't know the price until afterwards. And this is kind of like where the government does need to have some basis to know is is my best selected offeror. He could be the most expensive, but we don't know that, and we don't until after the fact when we look at the different pricing. So I think this really is, it's new waters. We need to tread lightly, but it's something that I'm willing to see. I know last year, for example, I'll give you a classic. We were going out for electronic working papers. We only had 2 bidders. One was really very good. Both were actually quite good. What tilted us to one vendor was because the association, Interior, all were going with that same vendor. But I would have liked to have known if his price was reasonable, if I could see what the other price was. I wouldn't have, we didn't open the other one because we're not allowed to open it, but what we paid for was that in the realm of reason compared to the other vendor. That's all. So it is something that we do need, and as John said, it is more in the service area. And it is something maybe we start to consider as a factor, but certainly the way you've defined it, not no more than 50%. So treading lightly into a new area, but supportive of the concept.
That's the difference between this version and what you find in the model code. When you go look at the model code section on the comparative civil proposal, it tracks this very carefully in terms of concept. I've just tried to make it less opaque to us who aren't used to dealing with it. But we're not the first government, other than the federal government, to adopt this. This is the standard throughout most of the country, is the best value method. And there's going to be varieties.
And that's it, John. I've been reading up on the rest of the country, and there's a survey out by NASPRO too. They make it free for 2015 and everywhere. And so that's why I was looking to see if I could find one that modeled what we're proposing so that we would be able to utilize that. My reason for raising it, because frankly it's good to have more tools for the government of Guam. It's just a question if you change the request for proposal as we know it, then what I'm saying is that a lot of agencies that I work with in the decision making and determinations won't have any choice, but they're going to be under this, and that is not what I believe your intention is. So what I'm raising is the impact of it and a little bit of what the complexity of it, because this is going to be complex, and agencies like DOE, UOG, DPW, and information technology, Chapter 20, they're more sophisticated in what they're trying to do as far as their larger procurements. But a lot of the critical reoccurring services that we have on Guam that go through the request for proposal process, or those, I'm looking at the federal grant funds that come in and go through a competitive process, like the victims of crime, the VOCA through the Justice Department. There's the peace grants. All of those, you don't want them to have to be going through this kind of process. You want them to be able to go through the competitive process of a request for proposal. And they currently can under the way everything is worded. And, you know, there are other ways potentially, and that's when I look at what's set forth in the 2 CFR Part 200, which is the federal grant rules and regulations that just became effective on in December of 2014, that are really going to take effect more for Guam. We had an ability to stay under the other OMB guidances and everything up until September 30th, 2016. But in line with that, my request is that we consider in the future, when we look at the next section on professional services, removing that professional licensing and allowing it to remain as currently written, have this in, and if at a future date, after this is in place and you have agencies that are utilizing this and there's regulations and it's moving along, then maybe putting things together a little differently.
If you look at what the model procurement office for state and local governments has done, they've eliminated the RFP method that we use in favor of this for everything. What we have done RFP. We just made it instead of we shall require professional service, we may require professional service in the RFP. So there is going to be flexibility in using the method, but there's a determination that has to be made. The head of the agency must make a determination that price is not intended to be the determining factor, and that the use of this, the alternate method, which is competitive bidding, is not practical. So that's, they could take a look at it and see if this is the right one. If you have anything you want to offer, you could have, if you've been thinking about this and studying it, we could get it on the table, but we don't have anything to look at it by way of an alternative.
No,
And this, as I said, is what I got from looking through the model procurement code and trying to stay faithful to that.
I simply passed you a copy, and Senator Ed, a copy of 2 CFR Part 200, the section that has to Section 320, which deals with the federal grant funds and the methods of solicitation that are permitted under the new law that I was just mentioning. I think you were at the training for FEMA had that Claudia was at, where they discussed all that. And so all I'm doing is bringing that to attention just to back up that really what it does is simplify things. It looks at certain methods, and it does not distinguish between those. And so a lot of states are reforming their procurement, which the history of the ABA model code and the regulations under it was in the Bar Association working with the federal government to make sure the state and local governments would be able to handle the federal funds in keeping. And so there's a close connection. And so this law just changed. And so the solicitation methods that are set forth in it are something that I'm suggesting that would be beneficial to the government of Guam to align with in keeping with the federal funds that come to it and keep things simple. You allow the competitive sealed proposal process, but you can still keep the request for proposal process that we have. It's changing to professionally licensed, and then you're removing one of the options that are there. The agencies still have to go through a determination process in keeping with fleet services as to what are professional services, and so that was what my concern was. It was like a two-level one. One, I tried to draft based on what you have here, what it would look like, a competitive seal proposal, and I ran into some issues because of the complexity on it. And then I was concerned with a large portion of what I see happen in solicitations that are under the law, in keeping with the law, but will, under the, if you change this later portion under professional services, will actually have to be under this request for competitive sealed proposals. And that's what I think you don't want to have happen.
For me, if we go start dealing with professional services now, we're going to cut out all the stuff in between. We're going to have to circle back so whatever the chair wants to do with that.
Okay.
When we get to that, I think that's what
Okay. Sorry, it comes up because I look at everything as a whole, trying to make sure that I'll be able to carry out the law. And I realize that a large portion of procurements that happen on Guam don't have any issues, and they're not in the public site. They're just moved smoothly along, and you don't want to interrupt those. You don't want to cause an issue.
And Mr. Chairman, I actually agree with John in that I think we should leave the competitive sealed proposals in and keep it bifurcated or separate from the professional licensing statute that is here. But they both coexist in their amended form in this bill.
All right. So we're going to go ahead and move on from this section 5. And we'll then move on to section, well, there was the last item on section 5 was on page 12 on paragraph G regarding debriefings. And on that particular one, that was highlighted because...
It's an option.
Well, the word debriefing I didn't like too much, I think, and I think I got an email from John. I just didn't have time to respond, but Of course, debriefings, the longer word for saying debriefing is the older military term. The longer modern one is after-action review, where you discuss what went right, what went wrong. I didn't like that phrase for that reason. I think the purpose of subsection G is really to disclose or have some kind of public disclosure where the agency makes the basis of their, or discloses the basis for their source selection decision, which I agree with. Instead of debriefings, I think the word G should say source selection, period. The procurement officer is authorized and encouraged to disclose via memorandum the basis for the source selection decision and contract award. And I think it would be clearer language. Of course, everybody in the military understands. Well, I would say people who were in the military for a while understand what debriefings mean. Most people today don't. But I think with the change in the language I'm proposing, they would be clearer and achieve the intent of the subsection.
But I think the issue when this got brought up, that the reason why we bookmarked it was the concern, the initial, I guess, concern that this was going to be mandatory, but it was, but the language on clearly says that the procurement officer is authorized and encouraged.
Yes.
But doesn't require it.
I was the one who wanted it mandatory because, and the rationale for that is many times, when we see these appeals, okay, it's just check, 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 and no summary afterwards as to why. But I'm willing to forego that and make it as an encouragement and say it's a best practice, because it just helps kind of elucidate what happened, especially if a bid is higher. Maybe the compromise should be is any bid over X amount has to have a memo, because the concern at that time was a lot of the smaller bids. But we do get a lot of, even in the hundreds of thousands of dollars where, who was the committee member? How did they, what was the rationale? And I was the one who wanted it more mandatory, and maybe a compromise might be to have it over $1 threshold to make it mandatory, and then encourage it below the threshold.
Yeah, well, just to respond to Tony, this language, except for the encouragement part that was added,
As opposed to mandatory.
is taken verbatim from the last section on competitive seal proposals from the model code. And that's their language. They use the term debriefing. They have a lot of comment on what debriefing is. The FAR, I think it's 15 part, talks about debriefings, and if it's not 15, it's in the FAR. There's a whole section on debriefings because they're not always required. It depends on the type of selection process that you're going through, and other factors. So I was just following what the model code was telling me to do.
Well, I understand, but I think we can use better terminology that the people of Guam can understand, and I think we just say source selection or source selection disclosure. I think that would be better than debriefings. I like the fact debriefing is one word, but it is somewhat, well, it's not vague, because I looked it up, it does have a specific definition, but I'm just trying to make it understandable.
And I think source selection leads you to think, well, is this an IFB and an RFP? So that doesn't really get you to the point either. You're saying that really you want the justification.
Or you could say,
Rationale for who, why, who.
you could
who
put,
selected.
yeah, justification would be acceptable to me, and
Yeah.
period, because the intent is just to or encourage disclosure of how you came about selecting a particular proposal over another. That's all it is.
That's
But
right.
I agree with that fully.
Did you have specific language?
I like the one word. Okay, for G it should say justification. Period. The procurement officer is authorized and encouraged to disclose via memorandum, comma, the basis for the source selection decision. I think that would be fine.
If I could, I think there's two things from listening to the last session. What you were talking about is what goes in the procurement record and a memorandum of why they chose, you wanted a new section, and that came across clear. my understanding about debriefing without any military background, just from a procurement level, was the reason it's there is so that a particular contractor, especially somebody new and has put time in, could ask to come in and talk to a contracting officer to find out about their own particular bid, sort of debrief on that bid and get some feedback on what they did or didn't do that they could improve on, and to understand that. That it's a special little category of a conversation that occurs and permits. My understanding on Guam is sometimes there's been it happens naturally because it's Guam and they come in and there's conversations after it's become an award. But, why, contracting officers are always concerned because they don't want to, have conversations. They're concerned about having it. So my understanding of putting it in, and the reason was because you wanted the contracting officer to know it's perfectly okay to have a conversation, to let somebody know what they could do to improve for next time, or, what the basis is. And I think as long as it's after the award and contract,
That's true. We do want to encourage that. But I would just make the point that under the FAR, there are certain debriefings that are mandatory.
but the FAR has other protections, and we're talking about the ABA model code and the
Yeah, yeah.
GCFR.
Yeah,
So
no.
that's what the problem of it is.
Yeah,
But yeah,
I'm
we
not
want to
saying-
have
yeah.
debriefings. It's the same thing when we're talking about the 4 principles in procurement. You want to have transparency and openness. It's good for government of Guam that more people are able to put in good bids or good proposals. You want to help those, especially, here on Guam where they're out there, there's new businesses that are coming into being. So we're all in favor of it. It's just kind of how it occurs.
Well, there's some issues there under Guam procurement law as it exists. Now, I know you're quoting the FAR, and the FAR probably has far more legislative infrastructure so that debriefing could take place. But, for example, if you have your contracting people talking to a vendor, even one who didn't succeed, or a bidder who didn't succeed, that conversation is supposed to be recorded and made part of the procurement record. It's not as informal as you might think, and that's under our existing infrastructure. So
After the contract's awarded,
That's the point of using debriefing, because there is a body of law about that. It doesn't necessarily require it to be recorded, and I think that using the memorandum kind of also sanitizes things too much, and a face-to-face discussion with the contractor, purchasing contractor, and the contractor, that they can look each other in the eye and understand things a lot better. I think that will yield the results of improving not just reducing the likelihood of a protest in that particular one, but making the next one a better bid for them. They'll understand better what's expected of them.
I understand the intent, but what I'm saying is you're going to need more infrastructure and protections because these debriefings. I understand your intent, but if they're not recorded, somebody else is going to come in and go, "What'd you tell that particular bidder who didn't make it? You didn't make enough payoff to the rest of the committee members or something, and maybe next time pay more." I mean, there's
so we should
there's another
strike.
side to that. So what I'm trying to say is, and I'm sure that the FAR has the infrastructure to prevent those types of conversations from taking place versus what we have here. We would need more than this one line if you're going to achieve what
Then
you're
we should
suggesting.
then probably take this all out, delete it. If
don't-
you're concerned about having, because it wasn't there before, it's a matter of being inserted. I was just explaining what my understanding of debriefing is in a procurement context versus a military.
This was there before. This was in the model code.
But it wasn't in-
None of the section was there.
The whole section is, okay. Well, and the reason probably with the request for competitive sealed proposal that they would want, and it would only be, because this is after award, right? It would only be after award because that's going to be a new procurement process and it's going to be a little bit more sophisticated. And if they weren't successful, that area probably the bidders' offers would probably want to find out what they didn't do right under it.
If I recall, go ahead,
Yeah.
go ahead.
Oh, I just realized now. My concern was for other procurements. This is strictly for the competitive seal proposal.
Correct.
Yes, okay. Hello, the light just came on, sorry, I apologize. Okay, if that's the case, why isn't it mandatory? Because on a competitive seal proposal, I mean, this is a new thing. This is, and rather than authorize and encourage, why don't you make it mandatory? Because of the whole process of it.
And I recall in an earlier discussion, there was one school of thought that the debriefing, by shining the light on the decision, for the award, may just say, oh, okay, now I understand. Otherwise, without the debriefing, then people are going to start then preparing their protest and all that stuff. And maybe the debriefing.
So we might be talking about two different things. Is this debriefing supposed to happen with the selected? And is it supposed to be public? Or when does this debriefing, because what I want, after it's all said and done, okay, is a memo to say, outline, that summarizes why Company X was selected. That's all I want. Wherever that is, the debriefing is maybe to me a different issue. So, and I think because this is a new procurement, and more than likely there will be an appeal, a protest and appeal, by having this memo that talks about why the committee selected who they selected and all of that, that will help. Yeah. And that's what I want. Now, the debriefing aspect to me is now an entirely different thing. If you want to debrief the person because this is why you're going to get it, this is what we want, that to me is more like contract administration. I'm talking here at contract award, to have something in writing for all parties to know why Company X was selected. The debriefing to me is a different issue. So that we might be, I think we're talking apples and oranges.
Perhaps, since that's what you're looking for, is that kind of a memorandum, and you're going to be writing the regulations. The regulations for the RFP already requires a memorandum of evaluation and negotiation, setting forth, including how the evaluation factors stated were applied to determine the best qualified, how the
None of that was
principal.
done in the RFP for JFK.
No, but
That's a different law, though. It had a separate law that they passed.
Yeah, but
And
that's
that was not
part
done
of.
for JFK, and that was a $60 million project.
But that's existing law.
Yeah.
Existing
All I'm saying,
regulation.
it
I'm
wasn't
No,
done.
that's
Yeah.
for the
And now,
RFPs.
because this
Oh, there's a
is-
similar provision. I just
because
didn't find it
this
real
is
quickly
in new
for
law, a
IFPs.
new source selection, rather than, we can re-emphasize it in the regulations, but it should be also in the law, because lots of times law and, don't always, and let me just say, in the JFK, there was no evaluation memo for that $60 million project. And now with this, I would like to see an insertion of a memo after the, why the committee selected Company A, the rationale for that. Because we do that all the time for our auditing contracts. It's about a 3 or 4 page memo that we put all the rationale for it. And we view it as a best practice policy. But now, because this is a new source selection, all the more reason to have this memo to memorialize how Company A was selected.
Isn't that pre-award?
What?
Best practice, you're going to
No,
memorialize
Company
it?
X is
afterward.
Selected,
afterward.
okay.
The briefing is afterward.
Yeah, afterward.
All right, because don't you write a memorandum before a determination of why, and because you're doing fair and reasonable price usually, and all the other items that go into why you're selecting it, and I've seen them, it is best practice, and we also recommend it. It's the procurement file, and it's pre-award, right? And then, because that's what you base it on for them to approve the award. And then after the award, you're now going to have a different document, and it's going to summarize
Well, what I was going to say was, what you're describing is rare. At the appeal level, they're very rare.
Yes.
And you have one unsuccessful bidder offer saying, oh, they didn't select me because there's something under the table with that particular bidder. And
This is
so although it's just a best practice, it's not something that's done
Again,
with great
but
frequency
it's-
amongst all the agencies. So all we're advocating for is a uniform practice. Take the best practice and make it a required one.
It's a requirement under 3114, and fortunately not all the procurements actually have appeals and come to you. But hopefully what's been happening through the trainings that are ongoing since I know our agency has done, and I know GCC is doing some, but we look for that. That's one of the items that I review, and all my assistant AGs, that Carl makes sure that we are looking for that in the ones that we're reviewing. So hopefully it's going to be something you see as a regular course. It's best practice for DOE, correct, to have a memorandum? It's sort of like the old-fashioned faucet with the hot and the cold. When you turn it, it takes a while for it to adjust.
Okay, but the memo you're describing is only required for the RFP.
The negotiation.
That's
A request for competitive sealed proposal is really an RFP as well. They're all under the same jargon, and that's what, if you look out and you do Google, you're going to come up with competitive sealed proposals and RFPs. The language gets intermixed like tomato, tomato. It's like information. I see ITBs. What is it? Invitation to bid. IFB, invitation for
Okay,
bid.
But
Yeah.
I know you're saying they're the same, but if you, my review of this particular law really sets the two processes apart. They are not the same. Not for what they are soliciting for, not even the procedure is the same. They are similar, but they are not the same procedure.
Which is,
So I disagree
we're
with
on the
you.
same page with the idea that there would be a new regulation like 3114 for this regulation, and it would then also require what you're talking about, the memorandum, as part of that. And that's what I said. I've tried to draft just with what we have, and I need clarification too from whatever's going to be in the regulation.
Did you find language that would have
Yes,
satisfied?
And
Yes,
3114M.
yes,
Yeah, that's a memorandum that,
yes, to have
but
all
that's
this.
not, yeah.
Yes, yeah.
But that's in the reg, and of course, that could be put in, this could be resolved via regulation as well, in terms of debriefing,
But the OPA is asking that it be put in the
statute.
statute.
Correct.
Because as they read it, they know it.
And so the language in 3114 GAR,
Yeah,
Yes.
GAR M,
Okay.
3114M.
is spot on.
okay, spot on. Okay. All right. Okay. We'll move on to section 6, small purchases. And in there, basically the change is that we increase the amounts, any procurement not exceeding $30,000. I think currently it's $15,000 for supplies and services, and anything less than $100,000 for construction. Right now, it's $50,000 is the threshold. So that's the changes that was made in small purchases.
This one will get a lot of attention by all of the agencies. I'm just seeking for clarification, and maybe I might be answering my own question later on. There is, and I don't remember, I'm not as exacting as these two fellows here, but my recollection is that it's at the $25,000 level that we have to advertise. So where will that change happen? Is that a reg or in the law? I can't remember.
Yeah, it's in the 3109 IFB requirement. And
That's a reg.
3114 mirrors, it says look to that for purposes of that and published. This doesn't say it has to be published, but you're right. It does create some ambiguity.
Right.
Small purchases do not be published.
Right. because this is the one this is the one that most people do need, and this is the one that I'm glad it is being changed, because this is the one where, inflation has taken place. But, clarity to make sure that it does not have to be advertised.
Who's going to issue an IFP for $25,000?
Yeah, right, yeah. So, but we should have, that's why I said I'm seeking guidance and clarification for this. And so maybe, as John said, maybe, and need not be advertised. So it's actually not, is it 30,000, so is it at $30,001? Or is it $29,999? Yeah, so that's another thing, Do you advertise it if it's over 30,000? In other words, it's got to be $30,001 in order to advertise? Or do you advertise when it's below, no, $299,999? So again, I'm just seeking the clarification.
Well,
Yes. But it's going to, because it's pretty close to it.
from a legal perspective, it would probably be, because the Supreme Court is faced with that issue,
Yeah.
well, you didn't advertise your small purchase.
Yeah,
They would have to harmonize that disparity in law. It would probably be a better practice if legislatively that was done so that they're in harmony, meaning
Yeah.
to say, we have to go back to the reg 3109 and say that it's procurements in excess of 30,000 that would have to be advertised, and then the law would be in harmony.
And that's
Because-
where you guys will come in.
Yeah.
We're
that's
just going
what
to
we
put
would-
language that
yeah.
says that small purchases do not require, as defined here, do
Do
not
not
require advertising.
advertisement, right.
Okay. All right. Move on. Section 7, sole source procurement.
I hate this section.
Let's see, and note 12. The whole thing here was, again, the issue about announcing sole source. So in paragraph B there, at the bottom of page 12, the agency issuing the solicitation shall publish in its website a notice of intent to award a sole source contract describing the nature of the contract and the intended contract recipient at least 14 days before an award is made. And then after the award is made, the agency shall post it on its website. The agency issuing the solicitation shall post on its website all sole source procurements awarded and remain posted for no less than 180 days.
I would add here, or the term of the contract, whichever is longer. Because you do say it shall not be more than 1 year, but there are annual options to renew. So I would want to know that if this sole source contract has been out there for 5 years. Or the term of the contract, whichever is longer.
Okay.
Do these contracts also include information technology
So we have, I was just asking Carmen, that the way, if we have solicitations below a certain dollar threshold, we don't do the three quotes. We go to, if we're buying something for $100, we don't necessarily, or $50, we might not necessarily go and get three quotes.
We go
We would go to direct.
That's
500
That
below.
portion is 500 below where you take telephonic quotes. But telephonic quotes have to be documented. And we didn't raise that threshold. Okay, so we're only, so if the 30,000, now that we've raised it, then maybe the telephonic quote threshold needs to be raised also.
But we don't even go to 3, right? We just got one.
Speaks to the
We
higher,
just got
there's two
one.
tiers in small purchases. There's the 500, which
Right.
has its own rules.
Right.
And then there's a 500 to 15, so this will apply to the 500 to
30.
30,000.
Yeah, but then my question is, why only 500? Shouldn't the telephonic, where she's coming from, because, due to inflation, maybe that threshold needs to be raised also. I like, and a simple way is, we are doubling this, and why not double that? Yeah, I mean, raise the, you don't need to go out and solicit 3 quotes for 1,000 and below, you just need to get 3 telephonic quotes. But you do need to document who you contacted. Yeah.
Where would we find the, the one on the where we're looking at the threshold for the, what was the,
Yeah, it's in the reg again, so that's by reg. So 3111 would be the reg for small purchase, where you have that bifurcation.
Yeah.
okay.
That way it's clearer, because this is the area that most agencies look at and do the most. So we do want to make sure that it is clear. And it is a good improvement, because it used to be 50,000, that's why you've raised it to 100,000. So I understand.
For construction services.
For construction
Yeah.
services.
So are we looking at increasing then that, the floor level from 500
To 1,000?
The reg on that is 3111, purchases of 500 or less.
Right. So that also should be raised to 1,000. Thank you.
Okay. Okay. Anything on paragraph D, a sole source contract shall not be issued for a term greater than 1 year. Let's see, what was the end note on that? The AG's office was concerned about how this might affect federal grants, and we addressed that in, I believe we addressed that in section 12, where we said that it, oh, no, right here on line 12. Yeah, federally funded programs, term limitations shall not be applicable to federally funded programs. Okay, so that's, huh?
I would say these term limitations.
Okay. Okay. All right, anything further? All right, we'll move on to page 15. This has to do with emergency procurements, the section 8 of the bill, starting on page 14. And the new language there is on page 15. And I think the more significant change there is that we have given the authority, we're going to be given the authority to your autonomous agencies who have been granted or delegated authority to perform their own procurement function. Approval of emergency certification shall come from their respective board of directors. Certified copies of the board approved certificate shall be sent in writing prior to award and as a condition thereof to the governor and to the speaker of the legislature.
Yeah, that's
fine.
perfect.
Okay? Yes, sir.
We are autonomous, but we don't have our delegate authority.
That's right.
And the existing emergency procurement, as stated and everything else, does nothing to help us out in the event of an emergency. Because we deal with equipment and construction, not commodities. So just like the autonomous agencies, we're in the same situation as GPA, GWA. When we have it, like when we had the emergency to get our generators,
Right.
it took a long while and everything else, and emergency procurement did us no good.
Right.
The way as is written here.
But I think under an emergency condition, what you would have procured under the emergency procurement provision would be maybe the rental of an emergency generator while you are working on bidding out to get a
Uh,
generator.
Again, when you look at the size of the generator that's needed, that's not widely available in the local market for rent.
It was
We're
available.
we're not,
It was available.
not for the amount, the numbers that we needed.
Well,
And again, all I'm saying is that, there are certain things in procurement. Again, when we did the top lifters, you can't go out and rent top lifters. So the emergency that we were in, the law did not help us out in any way, shape, or form.
So what are you asking for?
Kind of like to give us, until we get our procurement back or whatever, have our board of directors follow the same thing as the autonomous agencies.
I'm trying to recall, under your enabling statute, though, is, okay, for example, I know that GPA and GWA, because they're also under an elected board, same as DOE, they do have, they have to follow Guam procurement law, for example. I mean, under your enabling act, I mean, how does it set up? Are you part of that?
Depending on the price and everything else, it's the procurement plus, depending on the amount, PUC approval.
PUC approved?
Do you go through,
Well, yeah, because you have to,
GPA
because of the
has to
dollar
go
amount.
for anything in excess of a million?
1.5.
Million
Huh?
dollar
1.5
1.5.
million.
I
yeah.
knew it was at least a million.
Contract review protocol, that's before
Yeah,
the PUC
yeah.
and so on. Yeah, but, I guess, okay, are you so I'm not too familiar with the
Yeah,
board.
they are an autonomous.
They're an autonomous, yeah, so this would apply.
They're autonomous, but they don't have autonomy for procurement.
Yeah, they haven't been
They have to go
delegated.
through
With
GSA.
GPA and GWA, they have the authority by virtue of legislation. When the CCU was created, it
Okay,
also gave them then the authority.
so what's the issue with?
I think with DOE,
Well, they're not,
But you
they're
have,
not
a-
part
but
of
you
the,
have procurement,
yeah.
authority. They're not part of the centralized procurement regime.
you're pretty much autonomous. Yeah.
No, they're not autonomous.
I know
For reporting
GCC
purposes, that's-
is autonomous. I mean, they have their own procurement. They can do their own procurement
UOG.
by, and that was given by law, I believe. And so is UOG, I believe, right?
Yes, that's correct. So the
Yeah.
DOE falls in the same boat as GCC, UOG.
I'm not sure about the airport, whether they were given delegation.
Was the port given delegation?
No.
We originally, and then they withdrew it,
Who's they?
GSA.
And only GSA can be the decider?
I don't.
No,
No,
for procurement for, like equipment.
Yeah, that's why I said, is only GSA can be the decider to give it back.
Yeah.
Is that the intent now?
Well, I know that when we talk about GPA, GWA, and maybe even DOE, when they have an elected board, pretty much they're answerable to the voters.
No,
So that
I'm
was
not
one of the-
asking for any changes in composition or anything.
Uh-huh.
I'm just asking for something in here to help the Port Authority of Guam in terms of when an emergency comes up.
So if you're an autonomous agency and you somehow convince GSA to delegate procurement authority to you, then this would apply, because that's all it says.
Right, but until such time that occurs,
I think that has to be addressed.
That's a
I mean,
political decision.
no,
Yes,
it's not a
that-
political thing.
That's not a,
no,
more
I mean, the
in-depth
governor,
than
I mean, ultimately, the governor is the
Yes.
one that will tell GSA, delegate their authority to them, so,
Not by law.
Not-
Doesn't have that authority.
oh, okay.
Because she's independent of the government.
Okay, you're right,
So the DOA.
you're right.
So all I'm asking for is something in the
Yeah.
emergency procurement section to help us out in the event we have an emergency.
How do you find emergency?
Well, the equipment breaks down, the crane breaks down, and you gotta go out and buy a
You've been
crane.
maintaining it all these years and
Hey,
you didn't
things
know
happen.
that you wouldn't need a new one because it's
Well,
Okay,
we have-
we're
we
not
have a
gonna
service-
resolve, we're
not
not
gonna get
gonna
into
resolve
that.
it at this
We have a
session.
service life of till 2027.
We're not going to resolve at this session, I mean, I think it's a valid concern, but I think it's a separate conversation from what we have here.
but still an emergency.
He has to leave.
Well,
I'm sorry, ditto. I got it.
The last thing, on this, it says certifications
He'll be
come
off my
from
clock now.
the board of directors.
Sorry.
If in an emergency, that means that the board would have to convene,
We'll talk
and
tomorrow.
there may not be time. And I only bring that up because I recall after like one of the typhoons up at the airport, the gate, the perimeter fence was blown away. And so they had an emergency, they had to get that fence back up. And they had to go and do procurement now, and in the middle of this typhoon, at the end of it, there just wasn't, I can't imagine calling the board in. So
Yeah.
I don't know if there's any kind of wiggle room there. I just bring
You
it up
can
because that's
have
a real life
vote by
situation.
phone.
Yeah, and then
You
it
can
gets
do a vote.
ratified at the
Yeah, and
next board
ratified
meeting.
at the next meeting, yeah. I
Can they
mean,
do votes?
If it's
Some
allowed in their-
don't do that.
Yeah, if it's allowed in their regulations.
Well, I know that's how the utilities do it.
Yeah,
They,
yeah.
an emergency comes up, and they don't have that luxury of the 5 days, so, you
That's
approve
something
this,
addressed
this is
at
what
the
we need.
agency level.
Yeah, right.
Then it gets
yeah.
ratified.
And then you ratify it formally at the board meeting. And you make note who approved, who didn't,
Yeah.
who voted, who didn't.
We can continue the discussion on,
And I
on this.
got,
No, but I
that's all I'm
understand.
doing is reaching out,
Understand,
letting you know that we need something to help us out.
understand. And I'm also reaching out. Okay. All right, no further discussion on page 15 there about who shall approve the emergency certificate. On page 16, again, the requirement for posting, and on there, I think we satisfied, again, it was part of the OPA's concern about posting it for a period of 180 days or the duration of the contract, whichever is greater.
Right. Because
Okay.
it wasn't that other one, the sole source, it wasn't consistent.
Okay, we have 4:25. We can go for another 30 minutes, and I know that probably Section 9, I don't know if Section 9 is going to take us the entire 30 minutes. Again, I've highlighted on Section 9 on the RFP selection. The new language is limiting the RFP to professionally licensed services and changing it from prescriptive to permissive. Laura?
There's an impact with changing it to professionally licensed services, as suggested in the bill, as opposed to it overrules fleet services and what are professional services under Guam law currently, based on court cases as well as the code. And currently, there's an interplay between this section and 5212. Yeah, there are 121A, which is the definition of professional services. And I have brought, and I'm sorry I didn't have copies in advance, but I used some printouts from the screens that we use on a PowerPoint and a training on what an RFP is and the definition that we use based on fleet services, as well as a chart that we use to show what the thought processes and what is considered an other professional service. And state and local governments all across the country have been broadening that area of other professional services because there's new types of technology services that are coming into being. And so you need to have a little bit of room for that. And as I explained earlier, a lot of programs that we have here on Guam go through the request for proposal process, and the agency is able to make a determination, and they use what's in 3114. They have to comply with that as well. And they go to DOA to make sure that there's no current other provider of services within the government of Guam. There's scrutiny on it, and before they can go out and actually do a request for proposal. And what we ask, especially because the RCSP is going to be new in here, is that we leave the request for proposal process and leave other professionals in the way it's currently worded in the code and the regulations, and eliminate that professionally licensed language that's being added.
Laura, maybe I'm just seeking clarification from the court case, because that took, the Supreme Court ruling on that was, I call, a landmark case, okay, because it helped define what are professional services. And the end result of that case was these were contractual services, because professional services is viewed as buying brain power, whereas the bid that went out was not buying brain power. It says, I want a service. Because what DOA did, or whoever it was.
That was a mass transit, right?
Right,
When
there was
you-
the
It
mass
was
tran-
mass transit.
Yeah, was I not supposed to say that?
Yeah.
It probably was a competitive sealed proposal as well.
Yeah.
I've been trying to decipher it.
It was treated as if it were an RFP,
Right,
when in fact the Supreme Court ruled it was really an IFB.
correct.
Or should have
Yes.
been an
Yes.
IFB, because
Yes.
it wasn't buying brain power.
That's right.
It's like janitorial services. You run the bus, you clean the room, that type of thing. And that really is a lot. And how I always distinguish it is from professional services, because we do have janitorial services, we do have telephone services, we do have trash pickup, all of those. And those are really more IFB, low bid. And so what I always tell agency and staff, are you buying brain power or not? If you're not buying brain power, you just want them to do this because you've outlined, that is an IFB. Whereas if you want to buy brain power, like auditing to decide an opinion, an attorney, a doctor, then, so I just wanted to see if we're on the same.
We're on the same page.
Okay.
And that's what our current law is that way, and there's a distinction between professional services and services. And we're on the same page on that, and the only thing that's being injected here is licensed, and that limits what's considered a professional service. It doesn't have the ability, the flexibility that you need in order to carry out what Government of Guam does.
IT services could be, you really always, you want brain power in IT services.
And I just want to emphasize, because Government of Guam has been following procurement law in keeping with the case law as well as the code. And it's not that we're not, because it didn't require a license. There are licensed services that fall within this category, and
So you just want to take out the word license?
absolutely.
Because there are like IT services that are not licensed.
Right.
currently right now.
Once you do
And
li-
that is brain power.
Once you do license, then what you have to do, I mean, where I've seen it, they have other categories of procurement as well that then allow the flexibility of these areas that are going to be cut out or put over that. I'm worried about this, the human service type procurements that Guam does. And
Are you saying that human services are done through RFPs now?
they have been being done through RFPs that if they involve
The what kind of services?
professionalism. Not human, I'm talking about human health and services, sorry. He's gonna take me off the clock. Yes, so the reason I brought this, and it's just a tool, and it's what we use when we take agencies, governmental agencies, through what a professional service is, and what other professional services are. And it explains it, and that's, other professionals is an area that isn't, it gives some flexibility with it, but they have to, they have a guideline that they need to follow, whether or not it's professional services or not. That gave us that latitude. Well, and because of the way the way it's worded is other professional services in the statute.
My only problem with that is that we've given the RFCP, which allows them to put the prices no factor at all, so they can make a functional equivalent to this. But this has a ranking process that's required. So if you have someone who's providing IT services, you have to determine which service provider is the best qualified provider. You can't use it. And I just think that that really doesn't provide fair competition to the people. That it doesn't create the competition, because if you have one person who's the best, they're going to always get that best. They're going to get the job because well, they're the best, and so they automatically go to the head of the line. Whereas the other one, you can make price part of it. You can make other factors more equally important, or maybe even more important than that particular expertise that they have. And I think that we want to try to stick to the professional, because it's easier to determine rather than that amorphous fleet services description, and stick to licensed professionals. And if you're going to get it licensed professional, you're not stuck with the RFP process. Now you can use the other one as well. So I think because of the way you have to rank it, and you have to go to the very first one first, the top rank first, and get them if you can get a reasonable price from them. Not the lowest price, not even the trade-off price that you can with the other one.
Well, if I might, and that's a whole conversation, and I think it's not adequately covered at all yet, information technology under Chapter 20 and how those procurements go. I think the new RSCSP gives some room in that, but I think, again, you still have to look specifically at what's being procured. It's not a cookie cutter. And what I'm talking about is a lot of procurements probably that most people in Guam aren't even monitoring, but they get the benefits from because they go out. We have a lot of funds that come in, and there's multiple awards made, and that's what the RFP process permits. And if you have, and that's what, I don't want to call out any particular procurement beyond what I've already done, but if you go through and you look at different sites, and the reason I keep thinking of you, Senator, is that I've heard you at the appropriation hearings talking about, instead of naming a particular nonprofit, how you want to leave that just that they're going out for a competitive proposal process in order to select that nonprofit. And so you have a lot of homes by, the nonprofits run, and they come up for bid. The most they can go out is some programs, like the district ones, I think this is max of 3 years. The other programs are 5 years. There's a limit, a lot of them come up after 4 years. And they go out through a request for proposal process, because what they want to do is be able to evaluate the programs and make sure they're going to have the requirements. And there's a professional component in it. They're giving out the whole program to take care of. They're not reserving part of it like what was in fleet services, where the agency was telling what the routes were going to be and what time to pick up and all of that. Mm-hmm. And my emphasis is purely, or largely, not purely, on a federal funds standpoint as well. The federal funds come in, and they go through our procurement process and their competitive proposal process. The request for proposal allows the evaluation that takes place in the multiple awards as well. So I think there's going to be an impact that you're not viewing by adding that language in here and narrowing it. And if you're going to do it, well, the RSCP, let me try a different approach. The RSCP, we all agree, is a more complex, sophisticated procurement process, right? And you're viewing it as financing, design, build, information technology, and all of that. And we haven't had a lot of experience on it, and we need to get that experience. So adding it and giving the government that opportunity to go out and do that and develop it is great. I'm just asking that the request for proposal process remain defined the way it already is, so that we can also do those other procurements that don't require that other mechanism. They're working, and we're being able to utilize the federal funds, we're being able to take the programs out in keeping with the law. If you add in this definition and saying that they're only professional license that you can do through a regular RFP process, you're putting everybody else over into that more complex process that I haven't been able to draft. A multi-step bid allows you to qualify bidders, and then you have price. No, I'm not. It's not a multi-step bid if it's a professional service that they're carrying out for you. It's not a multi-step. The ones that are multi-step, they go out through a multi-step. And a lot of the programs actually are IFBs. They prefer to go to GSA because it's quick for them. Somebody else does it for them. It's, at least that's my experience. They would prefer, if they can, to go with an IFB, but they have to go through, and what I gave you is sort of the determining factors that we give them as guidance, and they make the determination. There's a written determination that's required, and then they get to go through the evaluation factors. There's a lot of different components that are involved in the specifications. It depends on the type of procurement. Banking, specialized banking services. Trying to think of some of the others. A lot of them is just that there's federal funds they're getting, and they have to take out a program that's totally compliant with it, and there's medical professionals or counselors involved.
So what I hear you saying
Yeah.
is that you would,
If
by
you,
doing professionally licensed, we're limiting,
yes,
and you want to open up because there are others, professionals who are not licensed.
And you want to be able to rank them.
I want to be able to rank them. I want government of Guam to be able to function. I want the government of Guam to be able to do what everybody's moving on and trained on, and following the law.
Without regard to price.
Well, I haven't fought you on price. But when I was at DOE, we always wished that we could have price as part of the RFP process, and I know people advocate that.
Tweak the RFC fee dollars.
Well, I get that, and I understand, because I listened to Doris explain it, that the reason, and I've read case from OPA that said the reason we don't have price as part of the RFP process is because it's negotiated and that's later. But my understanding from reading like NASPRO and other things is that it's highly recommended as a best practice to include price, and the reason why is that you eliminate the overly high and the overly low. You still negotiate it later, but you're not having to deal with those that are outside the range. So that's why.
And by not seeing price, you don't know who's high and who's low.
So-
And that's the quandary we're in. We don't know if the best selected offerer is the highest price or the lowest price, because we can only look at his price and without any reference to where it might be.
But that's an aside, John. I wasn't fighting you that on, or injecting that. The Office of the AG, we just want to make sure that the legislature and everybody here is aware of what the impact is. And it's sort of like knowing that there's a silent majority out there. I happen to have personal knowledge of the ones that I work on, that there's a large amount of procurements that are doing good things for people here in Guam, that you want to be able to go, and the agencies that are having, or not having, or taking out these requests for proposals, they're very thin on resources. They don't have a lot of people in procurement helping them. And the RCSP process and all of that is very complex. It's, it's going to cause you a lot more slowdown and trial and error as it gets up. And I don't think you want some of these critical services or the seniors and other people on Guam to be affected by it. So that's why I just want to raise it for you, because I know it's not what you're thinking of when you're looking at this, because you're looking at a certain set category of procurements that have come up that have gone through dispute. But a large majority of them are moving along. under the current law. So if we could keep the current definition of professional services without the change, that would be my request. Oh, can I leave?
No, what you're saying is on line 13 to remove license. So you'll read the professional services specified.
Right, because the definition wasn't effective, you didn't change the other definition.
Okay,
Because not all professional services are licensed.
correct.
Sorry.
Okay. All right. Chief, I know you stepped up to the table. You wanted to respond to something.
Well, since you wanted to talk to Jeffrey, I'd like to be in that conversation. So that I was.
No, I
at
need
the
to have a
board.
private conversation with him.
No, I had a,
No,
I
seriously.
was the
No, I
supply
understand.
management administrator in the park
Okay.
when we had delegation.
Okay. Okay. All right. We'll have
You
that.
can give some
We'll have that
additional
conversation. I'll assure you that. Okay. Okay. All right. So the change we're going to make then in section 9 of the bill is remove licensed. Yeah. So you'll read the professional services specified. Okay.
Thank you.
Okay. Let's see. And then on page 18, price is not a factor to be discussed or considered until after the ranking. And that's new language to existing law. I know you had a concern with that. What was 22? Yes, ma'am.
Currently, the law on Guam is silent pretty much as to it, but the interpretation and how we train all the agencies and how it's understood is that price is not involved in a request for proposal.
Right.
And I think what he was trying to do is insert it so that it's a statement in it. But on that issue, my earlier statements that when you put out a new law that it top cards everything else, if you put that in there and it says that, I'm not sure if you eventually someday may want some flexibility on that, just for the same reasons that we're talking about, that it would help on a fact-specific procurement maybe to narrow it so that you don't have the overly high and overly low if you had price in there. The federal government does include it.
The federal government doesn't have an RFP, it has the RFCP. It eliminated the RFP at the same time the model code did. which
But
was a long
the
time ago.
2 CFR 200, Part 200, that section that I just submitted, if you read that, which by the federal government, I'm only talking about the federal grant law permits it, price to be, if you look at that, it
They would
includes
permit
that.
it because they're dealing with states, and the states often have an RFP like we do.
Right, well, and that's why the federal government on the grant regulations, when they're talking about it, they're actually talking about organizations that aren't states. They let states follow their own procurement law, but they're talking about recipients, non-state recipients. And so they permit price. And it's for that reason, and this is an excellent book. It came out in 2015, but
about that.
yeah, it talks about it talks about competitive sale proposals, and in there it talks about best practices being, and that's interchangeable with RFPs in the midst of it. It's not the limited or competitive sale proposal. So if it's silent on it, it's okay. If it's added in it, it may limit the government of Guam in the future.
So you would prefer that it be left out?
If you leave it out, then it's the law as it is on Guam currently, unless there's a regulation that permits it for maybe information technology or other types of larger procurements where it would be to the best interests of the government of
Sure.
Guam,
Sure.
have it narrowed.
Yeah.
But if you're silent on it, it's still the law.
Yeah, I prefer to make it clear that prices, because we need to differentiate the three different methods. You know, where prices everything at one end, and prices everything at the tail end, and prices something in the middle. And if you start blurring the lines, we're really going to start to get confusing on how and when you enter into what kind of discussions, because the discussions are different from RFPs than they are for RFCPs. And we've got to keep them distinct. And I think we keep priced out of this, we don't ever see GFK again. And I think there was a retirement fund where they interjected price into one of their bid or RFPs, and it just confuses things. That's my personal opinion. I'm not the
Can we bookmark that and come back, both for coach
Are
and
we coming back again?
Hey, we're only on page 18. Goes all the way up to page 60-something.
Well, but I mean, what we've been
somewhere.
discussing, remember that Article 9 and 12 have been vetted in the 32nd legislature. It's had public hearings, it has roundtable discussions. I gotten vetoed twice, kind of telling us where the goalpost was. So we're going on the assumption that, we've addressed those objections, and so we don't need to go over it again.
I would beg
Well,
to differ.
actually.
I would beg to differ. I think this is kind of, because this has been a slow and deliberative process, and I understand your thing, but I think by having these other discussions, it just kind of helps us who are involved more in the process. And I know this is a very time-consuming process, and I do want to
Sure.
thank you for all of your good efforts and helping and highlighting these things. But to give an example, I have a problem with page 44 and my disqualification. Yeah. I don't want the Superior Court judge to tell me who's going to run my office. So, we haven't gotten to all these areas, and I think this discussion, while long, and maybe if we want to have another one next week, or, in the next, because I'm leaving next Saturday, so I'll make sure Anthony comes to kind of voice our areas. But I think this discussion has been helpful, has been illuminating, and I really would like to kind of see overall, so that maybe we can avoid, and the AG's office as well as Sandra can write and say, yes, while there are some pros and cons, overall we've gone through it and we are supportive of. But if you try to rush it without us having this discussion.
No. I'm not trying to rush anything. It's just that I think when we started with this, and Bill 162 was introduced, we decided to then actually put on top of Articles 9 and 12,
I know.
Article 3, on the assumption that Article 9 and 12 had been vetted quite a bit, and unless the goalpost is being moved again, then we're going to need to go back and revisit it. But this is kind of really the first time that this sentiment has been raised.
Well, I think what was vetted with respect to Articles 9 and 12 were the former Articles 9 and 12. And I want to echo the public auditor's appreciation of the senator, for having these roundtables, because you could see that this whole process was really much more complicated than we originally thought it was when the first bill passed through the legislature, and even the second one. And this bill is significantly different than the two previous iterations of it.
No,
And-
because Article 3 is attached to it.
Yeah.
But Articles 9 and 12 is the evolution of, the first bill, whatever it was, 224, that got introduced. It got passed. We had roundtables. We had public hearings. It got passed by the legislature. It got vetoed. And it was then more clear what the objections were. We took those objections, went back to the bill, incorporated, addressed the objections, and then reintroduced the bill, had a round table, had a public hearing, it got passed by the legislature, it got vetoed again, And this time, the goalposts, we think, okay, we think the goalpost is here. We took the objections that were raised in the veto message and again made the amendments in Articles 9 and 12.
So the amendments that were made to Articles 9 and 12 have brought us, I think, closer, but there's still a few comments, and we're not quite there. I do see some concerns.
So this will get vetoed again?
We don't know
No,
that.
not yet.
We don't know that.
Well,
We
that's
don't
what it
want a
sounded like.
veto. And when we had the public hearing before this, before all these round tables began, I came to that public hearing, and I said, we are closer than we are apart, and there are a few things. I wasn't going to go through every single little thing, and we were just kind of waiting so that we could bring them up at these round tables. I think if we had the opportunity, Public Auditor, Attorney General's Office, and I, to point out to all the participants here some of the concerns we have, I frankly wouldn't be surprised if we all just kind of nodded our head and say, yeah, okay, well, maybe that one needs a little tweaking. But the current versions of Articles 9 and 12 have not been, vetted, if I may say so, because we've never discussed them here at this round table. And that's all I'm saying. We just haven't discussed it together as a group. And this is a great group. I think
Every time we come, though, we got different people. It's not a group. This has been the problem. From day one, we had a lot of discussions over everything in 9 and 12 for 8 different sessions, 8 different groups primarily. And every time someone comes new, no offense, we start all over again.
And that is the process, and I think we have to accept that, okay, because we have different people at different times, different areas, and frankly, I have to say this, I like Laura's discussions. She has brought out different things that have really been helpful. We may not always agree, and that's what happens because you have a lot of professionals looking at it from different perspectives, and I think we're supposed to accept that. But if we can have our vetting, so to speak, and recognize we're going to win some, lose some, and hopefully at the end of the day, it's a compromise. It's going to be a compromise because we're not going to win everything. You're not going to win everything, and we all accept it as this is and I think that's where we're headed. Even though we're only on page 18.
Yeah, I guess my concern is that we can meet every week for forever and keep tweaking and tweaking and tweaking until it's perfect. And we're never going to see the end of that.
No, let's just take this version now that has been. This is the version. And we are having some tweaks as we go on this version.
Because Article 3 is really a new discussion. What we're talking about is that, and the other, you were saying that, and what started this conversation says, well, we're only on page 18 of 65 because the other half of the bill deals with 9 and 12, which were discussed in the last legislature.
And maybe it might be faster. We don't know. Yeah. But without this full vetting, and like I said, because we're heavily involved with procurement, and so is the AG, and of course representing the governor's position on this, I think it is a healthy discussion. And I agree with you, we can have roundtable after, but let's try to finish this one so you can introduce this bill.
And if I may say so, Articles 9 and 12 are the most critical of this whole bill.
Sure.
And it's the one that we should spend most of our time on. And if we have to go back and look at that anew every few months just to make sure we're right, then we should, because that's the procurement protest. This is all the public auditor does. Half of her time is these procurement protests. So she's going to go in and make these regulations. These regulations are going to be new, and we're just trying to simplify the process and maybe make her job a little bit easier.
Well, doing the regulations requires its own roundtable discussion.
Yeah.
You know, you got to have hearings on regulations. So that's all going to get vetted then. We don't have to.
6 months.
That's actually one of my comments, was that 6 months.
Yeah, I'm gonna die in 6 months.
So, just with all respect, maybe just, if we want to skip to Article 9 next time,
You know what
go
I
through
think
it,
we'll
or
do.
you want it in writing?
Yeah, what we'll do, I think, to move forward is fine. If every, a lot of people feel that we need to go through Articles 9 and 12 again, we'll do that. I think maybe we need to go ahead and kind of block off, the next roundtable discussion. We're going to discuss from here to here, various.
Well, we've tried that. Every roundtable we've had, we had done that. We've blocked it off. We're going to go from here to here and here to here. What I would really prefer to see is if there are these hidden, not spoken yet, not in a pejorative term hidden, but just unexpressed concerns that you've been holding and
I've
can't
been
wait to
waiting
get
for
to.
the time.
Why don't we put that on the table? Put it in writing so that we can ourselves look, well, yeah, that's pretty important. Let's just get rid of that one. And a lot of these things aren't all that important. What is an award? We don't know. So let's just leave it. Let's move on. We can, but we start all over again. We always start back at page 1.
I think for me to weigh in finally here too, in Article 9 and Article 12, we would really respectfully request a discussion and not just the opportunity to submit something in writing, because I think we've seen what can come out of a discussion is a better understanding, as opposed to us throwing paper on the table and trying to figure out what each other is saying.
I was not precluding the discussion. I was just saying it would facilitate the discussion if we knew ahead of time because you guys know what to talk about.
The AG's office was very involved in the crafting of Articles 9 and 12.
We're under specific instructions from Jessica to mention that there are new things in articles, those 2 articles that weren't there before. And so she wanted to make sure that we had the future discussion on it. We weren't sure, we thought it was going to be today. So we have both been through it, and we know that there are points that you really want to have a discussion on.
Okay. All right. Well, I mean,
And we can do it as early as next
I
week.
plan to be, as far as I know, I'm going to be here till December. I'm not sure if I'll be here in January.
Well, likewise for me.
Okay,
likewise-
so
likewise
I
for me.
assure you that if this discussion needs to, continue on through December,
No.
then we'll
I agree with
we'll
you to
do
have,
that.
and maybe what we now, because we have a bill, you've done a great job of highlighting the areas, and we do look at the highlighted areas, and if this is any indication, if we're, 18, 2 more sessions like this, we should almost finish it out. 2 more sessions.
I think we should do a word compare of Articles 9 and 12 as exist in here against Articles 9 and 12 that were in that last bill that got vetoed, and see what the differences are.
Tool tracks is always helpful. Tool tracks is always, because I always look at what was changed. But again, setting the time frame, because I'm not going to be here after next week, so I would like to have a meeting next week if it's everybody's.
Yeah,
Otherwise,
I'm in
I'm
the
just
same
going to
boat.
have to give it to Anthony, and he's going to have to just speak to me, and I've already talked to him about one section already that I want changed.
Yeah. Okay. Well, like I know,
There you go again.
I go into session next week,
I said
for.
it twice. I have said it twice, and you guys have completely ignored me.
Okay.
If I could, and that's
Sure.
what, I brought copies of the current mandatory dispute resolution clause, just because I know that you're going to go into discussions when you do go into it. It might be helpful to see how the government of Guam currently goes to contract and how we protect sovereign immunity. And this is modified from the Chapter 6 contract clauses because of Pacific Rock. And, there might be enough copies for, that's already copied. Thank you, sorry. I gotta go home soon. But I thought that might be helpful. My viewing, this is the clause the government of Guam uses in our contracts and has since about 2000.
Suggesting that the procurement process be
That is not, I'm not changing, no, this is what our mandatory dispute resolution, this is our clause, John. If you picked up a RFP and IFP that, and this is just a contract clause versus having a discussion just from a statute and what's happening. We've talked about how some of the laws in the statute and the regulations have been modified by case law. And so this is one clause that has been modified by case law. And I know when you do go into session, you are going to talk about protest disputes. No, this is, I'm sorry, this is our contract clause that we use, and I'm giving it just so that you have something concrete, so that you can see, this is what we put in to protect government of Guam as a sovereign entity. And this is how, it's a little bit different than what's in Chapter 6 clauses as contracts, because it was modified as to the money-only disputes. And I know that that's what you're going to be looking at. And so I just brought it kind of, I'm more a contract person. I look at contracts, and this bill, reading with all this back and forth, is, I want to make sure that I also let you know if you're going to impact something that way. And this is in existing contracts all across the board. And that's what you would be modifying that if you change things. And so we just want to make sure that when you do have that discussion, you understand that the sovereign immunity in 5 GCA Chapter 6 is involved in this, even though it's not noted in the bill itself. Okay. Thank you for listening to me.
Okay.
We want to have a meeting next week, don't we? Because we're on a roll now, I think.
Yeah.
And the problem has been in the past is that yes, it's been too long. And memory forgets a lot of stuff. Yeah. And I think with this one now, we're on a roll. Let's continue it and get it done quicker.
I go into session Thursday and Friday and all of the following of the week after.
Mm-hmm.
So, we won't be able to do it then. So the earliest we'll be able to do it next week is either Monday, Tuesday, or Wednesday.
Monday, we have a meeting.
Okay, so
Yeah.
that's out.
Monday
Wednesday,
Monday and Wednesday I have classes.
Oh, but Tuesday you don't. But not Tuesday. Tuesday is, I got to check my schedule to see if I'm, but if it's an audit meeting, I'll do it in the morning.
Tuesday looks fine for me in the afternoon.
Let's start at 2 o'clock because we got more done.
I've got to check to see if the public hearing room will be available, but Tuesday, 2 o'clock, we'll
Okay.
check to see if this room's available.
Huh?
Doris has public hearing.
We can use the Procurement Appeals public hearing room
Okay.
and we can record it then.
Fine.
The only problem is we don't have the video.
Sure, yeah.
But,
Yeah.
but we do record.
All right, let me check, and
Okay.
then I'll just send out. Did everybody put their email address on?
Sure.
On?
And I'll send
He'll be back? Okay.
Anthony a notice so he can be there.
Okay,
So if you do need
All right.
to, we can use ours. We'll
Okay.
have to reset it up, organize it.
sounds good. Okay, tentatively right now, there's nothing scheduled for this. Need to get with Rory's.
Well, thank you. It has been a very good discussion. Each time I come here, I learn a lot. Okay, gotta go.
Okay.
That's my-
This roundtable discussion will recess at this time.